Jim is also, he RSVP'd, and let me see who else RSVP'd. Erica can't come today. So I believe we're only waiting for Jim, but again, we have quorum, so it's up to, we can do housekeeping first too, if you want.
Yeah, let's go ahead and get started with housekeeping.
Okay. Great.
All right, welcome committee members, liaisons, and members of the public to the Rules Committee's meeting. Thank you for joining us. We will begin soon. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and do the same to lower your hand. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Now going forward, all LSTFC and committee meetings will be recorded and posted to the State Bar website. A friendly reminder that this is a video conference, and please be aware of your surroundings behind you. And a few troubleshooting tips. For those using Zoom on a computer, when on mute, hold down the space bar, and that will allow you to temporarily unmute. If you use your phone to dial into this meeting, please be sure your computer's microphone is on mute to avoid audio feedback issues. And lastly, while joining audio via computer is highly recommended. If an individual loses audio, they can call in separately using the Zoom conference number.
Great. Amin, would you like me to do roll call vote?
Yes, please.
Al-Sarraf?
Here.
Fightmaster? Bennett?
Here.
Blakemore?
Here.
Bushelli?
Here.
Connolly? Meeker?
Here.
Judge Seligman? We have quorum. Let me do our liaisons and State Bar staff. Melanie? I think I see you, Melanie. Okay.
Yep, I'm here.
Okay, great. Selena, I see you.
Present.
Elizabeth's not here. Crystal and Erica, I see you in the room. Meryl's here. Brady, is Brady on?
No, but Bonnie is on. I guess she just doesn't have her camera on.
Oh, okay. Great. I don't see any other State Bar staff. Oh, Corinne is on. She's also State Bar staff. And Kim. Okay, I mean, I'll turn it over to you to do public comments.
Okay, do we have anybody present who would like to make a public comment or identify themselves?
There's no one, but Zach from LAC is also on, but there's no other person.
Okay. All right, with that, then should we go to the next item on the agenda, the first item on the agenda?
Yes, which is approval of recommendations related to defining indigency. So this is Erica's, the staff lead on this.
Can you all hear me, or should I? So,
yes.
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 Great. Okay, so yes, I'll be going through the recommendations regarding defining and demonstrating indigency. The working group on this topic had been Bonachay Klagi, Chris Schreiber, and Jim Meeker. For those who have been on this committee for a while, you know that this is, I think, the third instance that we've kind of been revisiting this topic. And so we have a few items to finish up today, although we've made some good progress on other points thus far. So when we first started talking about indigency and how to focus on defining it and demonstrating indigency under the State Bar rules, creating a new State Bar rule, we had identified the current definition of indigent person as something to review under the Business and Professions Code, as well as the description of impact litigation and advocacy work under the eligibility guidelines, the Legal Services Project eligibility guidelines. So thus far, when we've talked about this topic, the things that have strike-throughs are topics that we've covered already. So The first thing that was handled was the definition of indigent person based on income under the federal poverty level. So as many of you may recall, there was a recent statutory change that increased the definition of indigent person from 125% of the federal poverty level to 200% of the federal poverty level, which started earlier this year. And that was something that, was initiated through the Rules Committee. Also under the statute, there are other classifications in which a person might be considered indigent. And those are individuals who are eligible for supplemental security income, individuals who would be eligible for services under the Older Americans Act, and individuals with developmental disability. So that was also at a prior meeting discussed, ways to sort of elaborate on or clarify those categories. We also discussed the pro bono allocation, but that's something we're revisiting today because the language around that had not been finalized. And we also talked about deducting disability-related expenses. So today we'll be focusing on the pro bono allocation and impact litigation and advocacy work reports. Impact litigation and advocacy work, commonly referred to as ILAW, are activities that, at least in the case of qualified legal services projects, they need to demonstrate a benefit to indigent persons when working on behalf of a group or a class of persons. Where you can't use that definition of indigent person under the Business and Professions Code, you can't apply it as easily because you're not talking about an individual, you're talking about broader, more systemic work. And so that's where the ILAW reports come in. So just to go quickly over kind of the timeline of this topic, it was first discussed back in October of 2020, when we first kind of like gave an overview of the topic, and when the statutory change was first proposed. Then there was surveys of the legal aid community, a webinar. We gathered a lot of feedback on possible changes to the statute. The commission designated a subcommittee on this topic, where there was a recommendation to make that increase to the income threshold, but not make any changes to our funding formula. And then ultimately the Board of Trustees adopted that recommendation as part of the State Bar's legislative priorities in late 2020, early 2021. And so, as I said, that statutory change was made in late 2021. That was the second time that we visited this topic through the Rules Committee. At that meeting in October 2021, we talked specifically about those income classifications I mentioned for individuals who are eligible for SSI, older adults and the like. And we also talked about, defining income and when it would be appropriate to make possible exceptions to income, such as in cases where there's been intimate partner violence. So that was the nature of the discussion at that last meeting. And then we also talked about the pro bono income threshold, which I'll get into more specifically, but at that meeting, staff was directed to draft language regarding the pro bono income threshold, as well as provide additional analysis regarding the ILAW reporting process. So in the interim, we've had some other topics that are sort of overlapping or related to indigency with civil legal services and primary purpose. So we're going to be both last week and this week kind of wrapping all three of those up. And today the goal is to finalize language in a proposed rule after we go over this pro bono income threshold and ILAW analysis. So as I mentioned, there's the Business and Professions Code section 6213D, which gives us the definition of indigent person, and then the Legal Services Trust Fund Programs eligibility guidelines, which are where you would demonstrate indigency in cases of working on behalf of a group. In both of these instances, there's no current corresponding State Bar rule that provides clarification or further description of these topics, and so that's what we've been working on, is establishing a new State Bar rule to assist the Legal Services Trust Fund Commission, the State Bar, and grantees in sort of understanding the requirements here. So under 6213D, there is a provision that states with regard to a project that provides free services of attorneys in private practice without compensation, indigent person also means a person whose income is 75% or less of the maximum levels of income for lower income households as defined in this section of the Health and Safety Code. So in addition to the now 200% federal poverty level income threshold, this section of the statute had historically been interpreted to apply to those organizations that receive additional funding under IL-10 EIF as pro bono organizations. So they have established that they recruit substantial numbers of attorneys in private practice and that their principal means of legal service delivery is through pro bonos. That's not defined in the statute, but that's how this section of the statute has been applied, is that it's for those qualified legal services projects that receive the pro bono allocation. When this was previously discussed through the Rules Committee, there had been feedback from the legal aid community that it should apply to any program that provides pro bono services. So an organization that doesn't get the allocation, but they might recruit some pro bonos for on an ad hoc basis or particular cases or projects. And there was a desire to apply this is a historically higher income threshold. So there was a desire to be able to use that when working with pro bonos. At the discussion at the last meeting essentially centered on that aspect and whether it made sense. And so with organizations that don't receive the allocation, it seemed like it would complicate things. There have been questions about when you partner with other organizations, which income threshold do you use? And that establishing these different income thresholds within organizations didn't seem to make a lot of sense. The other thing was that now that the statute has changed from 125% to 200% of the federal poverty level, this distinction is much smaller. So before the statutory change, pro bono programs really did have the ability to use a much higher income threshold, because this section of the Health and Safety Code that it's referring to uses basically a proportion of area median income. So depending on what county you were in, you could really use a much higher income level. Now that the statute has changed to 200% federal poverty level, in some counties that's basically erased the distinction, and in every other county it has reduced the difference in those income thresholds. So that was also some of the discussion at the last meeting, was whether whether there really was a fairness question anymore. And so ultimately, the outcome of that meeting was to direct staff to draft language to clarify that this section of the statute applies to only qualified legal services projects that receive the pro bono allocation. I know that in our most recent feedback from LAC, they had passed on a comment from some organizations that still feel that this question should be revisited, but the recommendation had been that since this was discussed before, to kind of move forward with codifying this interpretation. I don't know if Selena or Zach had anything they wanted to add on that point, but.
I don't think so. I think you've captured it really well. I think that because it's not clearly defined in statute, some organizations, disagree with the interpretation from OGC. And I'm not sure that it's hard, because I feel like the only other interpretation is that every organization that uses pro bono can use this higher threshold, and I'm not sure that was the legislative intent. Right. And so it's hard for us also to clarify, because that would mean that there's a higher income threshold across the state for anyone who uses pro bono. But maybe that could have been the legislative intent, to make it easier in order to get pro bono counsel, because that's often the justification. Is that when you farm out a case, you farm out the kind of easiest cases, and it must easiest cases to manage for pro bono counsel.
Great, thank you, Selena. So given that directive from the last meeting, and you probably saw this in the memo, there was a recommendation to add this highlighted language to the proposed rule. Because we've been doing this piecemeal, the rule itself, I don't believe has actually been, sort of recommended to the commission yet. So we've just added this to the current language that's already in there. So the recommendation was that only organizations deemed eligible for the allocation under 6216B would be able to use this this other income threshold or this other standard for establishing that a person is indigent and able to receive free legal services. So I don't know if anybody wants to discuss this part, because the next part is kind of more focused on ILA and is somewhat of a separate topic. So I don't know if anybody has questions or wants to discuss this part now or would like to wait until the end. Okay, hearing none, I will move on.
Looks like Jim has his hand up.
I'm sorry, I can't, if your hand is raised, maybe Dawn can help me.
Yeah, I can help you out.
I can't see who has their hand raised. So. Go
Yeah,
ahead,
I
Jim.
just had a question in terms of always referencing 6213D
Mhm.
based on the proposed rule down on the 3XX proposed rule on the capital D provision says 6218A or 6213B. And since both of those provisions or sections mentioned indigent, should we mention this 6218A along with the 6213D?
Sorry, I don't know why my screen keeps dropping out, but let me look up 6218A really quickly. Sorry, which section are you referring to, Jim?
6218A.
Qualified legal services programs shall ensure that funds appropriated pursuant to this article shall be used solely to defray the costs of providing legal services to indigent persons.
Right. And the only reason why I mentioned that is because in your proposed rule, section D mentions those two sections, 6213 and 6218. That's all. I mean, it's not being a licensed attorney. I don't know if there needs to be consistency when you refer to indigents or not, but I was curious about that difference.
Yeah, so subsection D is referring to financial eligibility guidelines established by the organizations. So that's why it's referring to 6218, because that's what it's also referring to. Is the first part of 6218 says all legal services projects and support centers receiving funds shall adopt financial eligibility guidelines, so for indigent persons. But I don't know if Brady's on the call yet. I don't think that it necessarily changes the interpretation, but we can ask if that's like a more technical point. I'm sure we could. Brady's here.
Brady is on.
Yeah.
I think he's looking at it right now. He looks like he's looking at it.
And as a slightly different question, maybe Selena would know this, but what do you do when one person in the household qualifies? Let's say if you have a multi-generational household with somebody over 65 in there and they have a landlord-tenant issue. Does that qualify even though the bulk of the household is not elderly?
I would suspect it's who came to the organization as the client. And I know in particular, especially in households where there's mixed immigration status, then organizations may represent one client, although of course, if they're representing that one client, it will help the whole household. So it's probably
Okay.
whoever came to legal aid and goes through the intake. But if I would suspect that in organizations where there are some who are not eligible and some that are, they may try to figure out how to help the person who is eligible for services.
Okay, so if you're having a problem with your landlord, you got to bring grandma in her wheelchair.
I mean, if she's on the lease, you would want to.
Yeah, okay.
Although interestingly, Stanford just released a survey on how organizations have changed their client intake and outreach strategies during the pandemic. And a lot of organizations are doing more remote intake and outreach. So for people who may have mobility impairments, their organizations are really working to do that kind of more responsive outreach.
Oh, good. Well, I don't need to hold things up. I mean, I could wait for Brady to.
Jim, was the question just that the prefatory language in the proposed rule for purposes of Business Professions Code section 6213D?
I was just wondering on the proposed wording on rule 3.xx on section D, it mentions both of those sections, 6218A and 6213D. And I was just wondering in those other things, the thing that Carol had up on the screen only mentioned 6213D.
Right, the very first under 3.xx, the very first.
Right.
Yeah, and I see what you mean. And I'm wondering if we could just delete that for purposes of I mean, that might be simpler, but I think we just need to think through carefully whether that.
Yeah, that very last line on D, whether or not you have to be consistent, that's all.
Right, and I think that's correct. So I'm saying, isn't the confusion the very, very first line of this rule?
Right. Only
That's
refers.
the inconsistency you're identifying is can you scroll up? Whoever's controlling the screen. It's this, for purposes of business, that
Yes.
only mentions D. Okay, yeah. I think we should look at maybe whether that line is even needed. If we could delete that line, the inconsistency would disappear. And as long as we're not creating any unintended consequences, I think I would support that. It's just simpler to say, hey, here's what income means. Here's what indigent person means. Obviously, we're talking about QLSPs. So is it okay, Erica, for us to just potentially see if we need to change that or can eliminate it to harmonize with the basically internally and with the statute? Is that can we put that on our to-do? Because
Yeah.
I don't think we can do that on the fly, but I think that that's a very good point. It either needs to be changed or removed.
That's good. Okay, were there any other questions on the pro bono piece? So I'll bring the PowerPoint back.
Pamela has her hand up, Erica. Pamela, do you want to go? Pamela, I don't think we can hear you. Okay. Pamela, do you still have a comment? I think she put down her hand.
I do.
Okay.
I do. Can you hear me now?
Yes.
Yes?
Yes.
Okay. This is I think my earpiece is just being bad, but I'll make it really, really quick. So again, page 12. My question is if someone is at the age of 60, are they automatically considered indigent because of their age?
Yeah.
And then also I was just wondering if a person with a disability, that may not prohibit them from having financial stability. So because of that disability, are they automatically considered indigent?
Right.
That was my question. Just, I'm almost there. And so I was just wondering, if you're age 60, does that make you automatically indigent? And I wondered if that's what we were trying to say.
Yeah, so my understanding of the Older Americans Act is if you are 60 or older, then you are eligible for services. But the act also goes on to say that organizations should be looking at things like demonstrated financial need, but it is not a firm cutoff. So, yes, the only requirement would be 60 or older, but I would imagine most of our grantees would also be looking for financial need as well on top of that. But the only requirement or restriction under the proposed rule for that classification would be 60 or older. That's right. And then for the for persons with disabilities, the way it's written, having a disability does not automatically make a person indigent. It's that you would calculate the person's income after you deduct or subtract out their disability related expenses. So you wouldn't just look at their gross income, you would look at it after you've kind of taken out any expenses related to their disability. So they may or may not qualify at that point, but that is the directive, is to make sure that that is taken into consideration when trying to establish indigency.
And I think just one part on, I know Catherine probably has more information on the disability eligibility requirement, but on the the age-based one, it's a statutory definition, connected to the Older Americans Act, and means testing is prohibited in some cases, but on the flip side, organizations are encouraged to do specific outreach for vulnerable populations, and there's language to say target your services. It's all around targeting services. And so the reality for senior legal services providers is that they will provide more brief services to people who have means. And I have talked with executive directors who will say, someone will come to them and say, I need help with my trust and estates. And they say, well, why don't you hire a trust and estates attorney for that? Because we're just a legal aid program. But they because of some of the funding, they cannot turn away some clients, but they may provide a lower level of services to be able to target their attorney time and advocate time to the people who really do need help.
Will, you had a comment?
Yeah, I was going to wait on this question, but since Pamela has already brought it up, I am just curious about the alignment here with the statute. In 6210, I think it says free services for the Older Americans Act and the Disability Act. And here, as I read it under B, it's, are you 60 or do you have a developmental disability? And then you are defined as indigent for the purposes of this provision, unless I'm missing something. And I welcome feedback on what I'm missing.
I'm sorry, I'm not sure what the.
So maybe it would help to 6210, lays out that it's, so you're eligible if you get SSI or free services under the Older Americans Act or Developmentally Disabled Assistance Act.
Mhm.
And that seems to imply that there is more than just a requirement for age to me, or developmental disability, but rather you have to qualify for those free services.
Yeah, I can take a stab at that, Erica. So the Older Americans Act, depending, it's very long, and it references like how you receive services, and there's different sections reference like different age. Some are 60, some are like 64. I can't remember all the iterations, but I think we were trying to simplify it. So our office has always interpreted that section, the Older Americans Act, is to be 60 and above. This is kind of widely understood that we've had this interpretation. The legislature knows that we've interpreted like that, and everybody feels comfortable with that interpretation.
So I understand that, and that was my understanding. Although on the Developmentally Disabled Assistance Act, what I was hearing was that from Erica was that you're not, that you're not eligible under that. You don't have to just meet the definition of developmental disability under 42, section 150002, but also there's some income requirements.
No, well, there's
No,
two different
yeah.
things. So if you have developmental disability, you qualify. If you have
Oh.
other identified disabilities, then you would need to take into account their income after deducting their disability related expenses. So
Yeah, so there's a couple ways on how to qualify, right? So, yeah.
Okay.
So we
So
don't have to
the
work.
disabilities is relevant in one of two ways. If it's developmental disability as defined under 42 USC, you are qualify as indigent no matter what.
Yeah, no income screen
if-
there, just, yeah.
If you're physically disabled, then you qualify under one of the other definitions, the actual income definitions, but you can modify how you do that calculation based on your disability expenses. Okay.
Does that answer your question, Will?
I think it does, as long as there's
Okay.
no concern that because we're leaving out free services, that there's some qualification that we're leaving out. I am all in favor of simplicity, but I don't want it to come back and bite us if there are additional eligibility requirements.
I mean, you raise an interesting point, though, this whole discussion does, because the way the statute says, are you eligible? And it sounds like as long as you're 60, you're eligible for some free services under the Older Americans Act. So I think that if this resulted in this is honors the text of the statute. I think that we would all be uncomfortable if some organizations just started. I'm offering free services to wealthy 60 plus folks, and I'm going to get a grant. I think that we'd all be rightfully uncomfortable with that. And I think we should pay attention to who's qualifying under that provision. But I think this is sort of consistent with practice and the law now.
I think Brady summed it up excellently. That would be a less than ideal outcome. So as long as we keep an eye on it, I don't think it's going to be an issue, but I did want to raise it and make sure I was understanding it properly.
Thank you, Will. Pamela, do you have a comment or question?
No, I just totally agree with that assessment. That was, to me, income, the eligibility based on income has to be just that, to avoid that problem in the future. So I totally agree with that.
Jim, go ahead.
Just to follow up on Brady, so if Bill Gates, since he's 66, he can't come in and ask for help with running his foundation, right?
yeah, I mean, I think as Selena noted that, under the Older Americans Act, there are provisions that do require some income restrictions, and that needs to be taken into account. But in others, it's not required. So, where they can't do means testing. So, if you're eligible under the Older Americans Act, I think and that's what the statute says, that if you're eligible under the Older Americans Act, the rule also needs to be potentially as expansive as possible based on what you could qualify for under the Older Americans Act. So I understand the concern, but I don't think that that's happening in most instances. So. Any other questions? Okay. Then I'll move on to talking about ILAW. So the next part of the topic, we'll be talking about demonstrating indigency in impact litigation and advocacy work reporting. So this is reports that we receive currently on a yearly basis, where the grantees report on their work performed on behalf of groups or classes of persons rather than individual clients. And the main thing I want to note is both types of grantees, both qualified legal services projects and support centers complete these reports, but today's discussion is only focusing on the qualified legal services projects piece because support centers have different requirements and support center topic will be dealt with a separate meeting. And so we'll just kind of be talking or focusing our discussion on the QLSP piece. So under the current eligibility guidelines for legal services projects, when they report out on their advocacy work or impact litigation in the prior year, the eligibility guidelines lay out these 7 factors that they should be describing or looking at when talking about their work in order for them to demonstrate that it's work performed on behalf of indigent persons. So ask about the forum, whether the named plaintiff is indigent, the definition of the class if it's impact litigation, a description of the group of individuals who would benefit, whether a majority of those who would benefit are indigent, the relation of the issues raised in the matter to the legal needs of indigent persons, and then finally, whether indigent persons are disproportionately affected by the legal issues raised. And I sort of highlighted the majority or disproportionate impact piece because that's kind of what our prior discussions have focused on the most. So the eligibility guidelines, the commentary to them after going through those 7 factors, it has language that says that organizations must quantify the percentage of their clients who are indigent and the percentage of persons who would benefit from services who are indigent, and they have to explain the basis for making that calculation. So historically, this has been the piece of bylaw reporting that's been the most difficult, both for staff and for the grantees for reporting purposes. We received a lot of feedback the first time that we put this out for comment that organizations just may not have that type of data available to them. And they can make an argument as to why they undertook a certain activity, how they think it's going to benefit indigent persons. We also got, some helpful feedback from LAC and public advocates, which is one of the grantees, directly about, that a lot of the work that's being performed, it's not isolated to indigent persons. These are activities that are affecting entire communities, and you can't necessarily confine it to just the needs of indigent persons. And so wanting to take a more expansive view, looking at things like disproportionate impact versus a majority of persons being impacted. There's also sometimes just a dearth of independent data out there for organizations to support the claim that they're, providing these services to a majority indigent client base. So when we first were looking at this issue and ways to potentially assist with improving the process, one of the things came up also was that organizations are reporting on, we have a little over 100 grantees. Every year they have to report on these activities. We're getting anywhere between 800 and 1,000 activity reports that staff has to read through in a period of about a month and a half and make recommendations on whether the activity is qualifying or not. The grantees themselves were spending enormous amounts of time completing these reports. And so the feedback was that it would be helpful if we could streamline the process or make it, more, just ease the reporting burden. So the initial proposal, I believe this was last year, was to set a minimum threshold for reporting. So not every advocacy activity would need to be reported, but maybe, if it's under a certain percentage of the legal services hours or under a certain hour cutoff, that organizations wouldn't have to submit reports. In the current guidelines, actually, it does say if it's under 10% of the legal services, organizations don't need to report, but that's not currently enforced. We have organizations reporting on all activities. The guidelines also say to report on 10 activities, but we actually have them report on up to 25. So there was definitely a desire to reduce the amount of reporting. When this suggestion was made, the feedback was to use the greater number rather than the lesser number. So if it's 10% of legal services, or 100 hours, whichever is greater. And so that was the point at the last meeting, that staff was asked to analyze further the ILO reports that we received most recently, to see if this would be a workable approach under either system, whether you're looking at whichever is less or whichever is more. And I can kind of talk through some of those data points or that information in a minute. But the other thing that was included in the prior proposal was a way to establish the acceptable means of demonstrating benefit to indigent persons. So currently it's treated as if you can show a majority of persons impacted or indigent, it's qualifying. And then on a case-by-case basis, the Eligibility and Budget Review Committee has also looked at reports that assert a disproportionate impact, but those are not considered like automatically qualifying. That's something that the committee looks at. So the recommendation was to allow either basis, as long as it's supported by evidence, to establish that it or demonstrate the benefit. The other recommendation was to provide independent data in either circumstance. So whether it's a majority or a disproportionate impact argument, that there has to be data to show that benefit. The feedback we had received on that was, again, sometimes it's difficult to get that independent data or analyses. So organizations may be able to use internal data, like their own reports, their own evaluations that they submit to the state bar for other grants, where they can take a look at the needs of their client base, what people are coming in saying they need assistance with, and establish that something may be a major area of concern for a high proportion of their clients. We had also received feedback that maybe if they don't have the internal data capabilities to be able to rely on other legal service providers or other community-based organizations in order to justify the activity. So since that last meeting where staff was asked to look into the ILO reporting more closely, some of the things that we found when looking at the full set of activities that were submitted from 2021 is that, about a third of grantees just don't engage in ILO activities at all. So they're not really affected by the reporting burden, but the remaining 70% are. Those that do have to report, on average, they're reporting about 12 and a half activities per year, or that's what they reported in the last year, I should say. Having them report on up to 25, there may be some organizations that do that, but on average, it's about 12 and a half activities in the prior year. We also found that there was high variability in the number of hours devoted to any of these activities. Some of them, it literally could have been an hour or two spent on the advocacy work, but it could also go up to like 1,000 or, possibly multiple thousands of hours in a given year, depending on the size of the project. So again, for the organizations, like the reporting requirement is the same, no matter how much time you spent on the activity. And it did seem that if you're spending as much time filling out the report as engaging in the activity, is there some sort of de minimis, something that might be considered a de minimis amount that would be appropriate. Also, I think we had established that if you set a minimum threshold in terms of hours, that if you started at like 50 hours or more, that would reduce the reporting burden by about 40%. And if you set the minimum at 100 hours per activity or more, it would reduce it by about 60%. So having some sort of minimum threshold would also be a potential alternative to dealing with the reporting burden. So in light of that, there was one suggestion, continue the reporting every year, but limit it to their top 10 activities based on hours devoted to it. And that, only at 50 or above hours would it need to be, the report need to be filled out. Another suggestion from staff was to continue 25 activities reported out, but do it every 3 years, coinciding with the year of the monitoring visit for our organizations, based on their work in the preceding year. When we had sent that out for feedback, LAC had been supportive of the second option. The reason that the every 3 years piece was suggested by staff is because a lot of these activities are actually ongoing. You may be involved in impact litigation for multiple years. And so if it's qualifying in the first year, it's likely to be qualifying in the third or fourth year. So the idea was that if you do it every 3 years, you're still likely to capture a good portion of the work that's being done, but without needing to do it every single year. Obviously, the flip side of that is there is the possibility that some non-qualifying work might not be identified. And non-qualifying work for QLSPs is important because it would impact their primary purpose, as well as their potentially their allocation, their funding allocation. They would need to take that out in their application for IL-10 EAF funding. So that was sort of the potential concern identified with that. But staff doesn't necessarily think that that would be a highly likely situation that like major amounts of non-qualifying work would go unreported, because most of our grantees are actually aware of their impact work that they're doing that isn't qualifying when they're not necessarily working on behalf of a majority indigent client base or a topic that's not disproportionately impacting indigent persons. So I'm sorry, Jim, you have your hand raised.
First I want to applaud you on the analysis for the hours that you reported, the mean as well as the median, which shows that these distribution of hours are highly, highly skewed.
Yeah.
I mean, they go from from 100 to 308 is a big variability. I was just wondering, did you calculate the median also for the average or for the reported number of activities? Because it looks like 30% have no reported activities at all. And of the 60% that do report activities, 30% show only 10 or less. So that suggests that distribution is also highly skewed. And is there any characteristics of the programs that have these high number of hours and high number of cases? Are there any similar characteristics? I mean, are these programs that are very, very large, or are these all LSC funded programs, or was there any other pattern that you could discern?
Yeah, so I think one thing, thank you for mentioning that I should point out is when we did the analysis, in retrospect, perhaps we should have tried to pull out the support center work, because in terms of reporting the numbers, we included support center hours, and because support centers, one of their primary activities is advocacy support for qualified legal services projects, they do tend to have a really high number of activities and hours reported. So it may be the support centers are kind of like bumping up the hours. But I would also say generally among qualified legal services projects, I would agree it's usually the larger organizations that tend to have the ability to engage in more of the advocacy work. But that's more anecdotal. I don't have an exact figure for you.
Okay, well, because I thought from what you were saying earlier that this analysis was only on the qualified legal services providers, but you're saying it does include the support centers. And
Yeah.
if that's the case, if we're going to analyze support centers later on, that suggests to me that we ought to have the data broken out by qualified providers versus support centers, and we may want to have different rules for those two, because the support centers, I would think, are engaged in a lot more ILAW activities than your typical provider.
Yeah, so the proposed rule would apply only to qualified legal services projects. It's just when we ran the report, it didn't separate out QLSPs versus support centers at the time. So the numbers do include support center activities. What I can tell you is that, we did the average, including all organizations, and the average number of activities, I think, was about 8 or 8.5. And then when we excluded those that didn't have any ILAW work, that's when it went up to 12.5. So that is inclusive of support centers, but it's also inclusive of the QLSPs that engage in those activities. But the proposed rule would only apply to the qualified legal services projects. And QLSPs are the majority of grantees. They're about 3/4 of grantees versus 1/4 being support centers.
Catherine has her hand up, Erica.
Okay.
Hey, thanks. Just a couple of questions. One has there been any thinking about, sort of a percentage? It's like the large programs like mine had a lot of this work. At one time, we were actually required to report everything we did, and then we were grateful that it was, only 25 because that was a lot less. We probably had 100 or so. Not all of them met the number of hours threshold, but should there be a different number depending on the amount of work that you do that you report, right? So 10 cases for a very large program is going to not be a particularly significant percentage of its overall ILAW work. It's going to be small, but for other programs that might be right. So I don't know whether there's just some thinking about what should those percentages be. I think the burden on the programs is the level of detail that's required, or at least was when I was there. I mean, it was this like A through, I don't know, F, G, H, I, some large number of things that you had to report on every single matter. And I don't know whether you need all that information or how it's used, but one way to make it less burdensome seems to me to kind of reduce that for both the people reviewing it and the people preparing the report. And then my last question is, I know that I think when we've been in the rules in the eligibility committee, when we've been reviewing eligibility, I think it's often these larger issues that come up that we have staff has reviewed and then we've reviewed, and we have in fact made certain things not eligible. And so I guess I'm trying to understand the nexus between that connection. If you go to a 3-year cycle, but we've been finding some things not eligible for funding, like, aren't we losing that information? So anyway, those are my questions / comments.
Mm-hmm. Yeah, so to start with your last question, yeah, there is that possibility of doing it every 3 years. Every year there is a certain amount of activities that are reported out that are non-qualifying. I think in last year's set, there were about 40 activities that were non-qualifying, but all but 2 of them were reported either by the organization or after discussion with staff. When the organization agreed after discussing the issue further, that it was non-qualifying. So it is possible, yes, to potentially be overlooking non-qualifying work. It being likely only a handful of activities, but you do underscore an important consideration, which is that it could be a high amount of hours. So the correlation of the hours to the amount of expenditures related to the activity, it could be high for a particular, an individual organization. And so that is kind of one of the potential drawbacks to the second option, by reducing it to once every 3 years. I think the hope would be that with, improved guidance about what's qualifying and what's not, that organizations would be better able to identify themselves the non-qualifying work, because it is incumbent on grantees to deduct non-qualifying work. And so whether they're submitting a separate report on it or not, they should hopefully be able to identify and then deduct that non-qualifying work themselves when they submit their IL-10 EAF applications. This is sort of a safeguard or an ability to double check that work, but the hope would be that with better guidance that would become more routine or easily incorporated into the deductions on the application. And then let's see, trying to think of your other questions.
Like different standards, should there be a standard based on the amount that you do? So maybe at the low end, it's report 5, and at the upper end, it's report 25, so that it seems, I mean, there's just such different, it goes to Jim's point, there's these very large ranges and very large ranges of hours. And for programs that do more of this, it seems like part of the trust fund's obligation would be just to look at more rather than less for, because everybody has the same lower threshold. So that was my second comment. And then it was a comment about just reducing the amount of information you require, which is what I think is burdensome to programs. And like, do you actually need that in the initial report, as opposed if you're following up, you're going to ask it about specific things. But it starts like with cases like the name of the case and the court it's in and the date it was filed and is it a class or isn't it a class, and all kinds of information about it. I'm not really, what you need to know enough about why is this case eligible. And then if you want to do follow up and look at the pleadings yourself, then ask the program for more work. So I just think there's a better way to potentially focus on what you need to know without like reams of paper coming in, which make it harder for you to review and harder for the programs to provide.
Yeah, so the way that reports are currently structured, and if you're not on eligibility and budget review, you probably wouldn't know this, but for those who are on the committee and have seen the reports, they are quite long. And the way they're structured, though, it corresponds pretty directly to those 7 factors that I outlined before in the eligibility guidelines. So, you know, the factors being like the forum or the description of the class and things along those lines. So, you know, I think the new proposed rule doesn't necessarily require those explicit or specific factors. And so I think there would potentially be a way to cut down on the amount of information that needs to be input. I can't say that today. I have sort of like what the new layout would be, but I think that would also be the hope, is that you're just getting to the, you know, the heart of it, which is, you know, how is it civil legal services, and then how is it services to indigent persons, and, you know, what is the basis for that belief that you believe you're, you know, working on behalf of a majority or disproportionate impact type case. So, and then as far as the question about sort of the size of the organization or the amount of ILL work that the organization engages in, I don't necessarily think that there's been that discussion. I think with just reducing the number of reports overall, that was intended to be beneficial to, you know, if they have fewer than 10, then they don't need to complete all of, you know, obviously all of them, but I think that what we do now is organizations that have more than 25 reports that they could potentially submit, is that it's based on number of hours. So they need to prioritize submitting reports with the highest number of hours devoted to the activity. And then any other work that they engaged in that might be classified as impact litigation or advocacy work, they need to provide a summary, a general overview of those other activities to provide an opportunity for staff to follow up with them if there's anything mentioned in, you know, the summary of their other work that is concerning or questionable. But I think the idea was that, you know, if you have the top 25 currently, that's a substantial amount of work, especially if you're doing it based on number of hours devoted to it, that once you get past that it might be a smaller proportion of the work that's not submitting an individual report. But yeah, I mean, I definitely understand sort of the potential benefit for organizations that aren't doing as much work, whereas you also want to capture enough of the work for the organizations that are doing more than can even fit in 25 activity reports currently. So that is
it just seems like, you know, 10, if you're a program and you have to report 10 and you have 10, that's 100%. And if you're a program that has 100 and you're reporting 10, you've got 10%. And so I guess I don't really know if it matters, but it seems like you could have a percentage threshold of what people are reporting that would make it less burdensome for smaller programs. So if the threshold is 10% and not more than 25 or whatever it is, or whatever the number is, then maybe that makes more sense to get a fairer representation among the programs, as opposed to everybody does 10, which is going to be, for larger programs, I think a pretty small percentage of what they do.
Yeah.
Anyway, that's it.
Yeah. Thank you. And I think that doing it that way in terms of proportion, I think we've been looking at it sort of the opposite way in terms of like, you don't need to report unless you, in the initial proposal, you wouldn't need to report until you meet this threshold of percentage. But that was a concern because a lot of work, as you said, for larger organizations, like if you didn't need to report until you reached 10% of your legal services in the prior year reaching that threshold, that could be a lot of work that's potentially going unreported. So yeah, I think that's a helpful comment, and hopefully others might have thoughts on that during the discussion in terms of whether it makes more sense to establish that percentage. Not so much as the trigger for needing to report, but the sort of different cutoff points for what amount or proportion needs to be reported out. So.
Yeah, to follow up on that point, I mean, you have the number of hours that they're reporting for the ILAW work, but do you know what their total number of staff hours are?
We could do that. You mean like total number of staff hours for the year? Yes, we have that.
Yeah, because it would seem to me that, if the ILAW work represents 20% of all their staff time work, that's a lot more important to check those people as opposed to if it only represents 5 or 10% of their total work. And again, I would think we'd want to establish rules for qualified legal service providers that are different than rules or cutoff points for the support centers, because it seems to me this is a primary business orientation for support centers, more so for just the average provider.
Mm-hmm. Yeah. So yes, we do, as part of the application process, organizations report. There's a staffing table that they fill out in terms of like the number of staff that they have, as well as like the total number of hours worked in the prior calendar year. So there is some potential for comparing those. Yeah, and I think organizations also report out currently on their volunteer hours also dedicated to this work, but they're kind of reported separately. So there's the ability to see staff versus volunteer time. But and I agree with you in terms of sports centers versus QLSPs, which is why any language discussed today would only be relevant to qualified legal services projects, because support centers have enough difference in terms of the nature of the organization itself and the work that it does, that it doesn't make a lot of sense to create a rule that's going to, in this instance, that's going to be equally applicable to them, or in because the standard is different. So so in addition to talking about the reporting burden, there had also been, discussion around establishing ways to demonstrate benefit. So the current proposal is that move away from only considering it qualifying if it's the majority of persons impacted or indigent, to also allow organizations to use a disproportionate impact analysis. So if they can show that based on the nature of the activity and the work that they're doing, what it is they're hoping to achieve, how that relates to the needs of indigent persons, that they could also establish that as qualifying work. Because, as I mentioned before, that a lot of the work may not be confined to the needs of indigent persons. It may impact large proportions of individuals in the state or in, the community in which the organization operates. And so if it could have a very meaningful benefit to the client constituency, and it may also impact other individuals, whether that should still be considered qualifying in many instances, and has been considered qualifying in many instances. So, so that's the recommendation, is to clarify that they would either demonstrate a majority or disproportionate impact. The preference is for a majority, but that they can use the disproportionate impact analysis if they need to. And then again, that there would need to be evidence to support their claim that, you know, the group impacted really is indigent, or, you know, that there really is a disproportionate benefit or impact in this instance. So again, the proposal outlines use of independent data, but it does also expand to, you know, internal organizational data, community level data, you know, from other legal services providers or community-based organizations. The examples given were meant to clarify what would be acceptable, because currently under the guidelines, there isn't necessarily further articulation of what it means to, you know, demonstrate the majority are impacted. So those examples are not meant to be restrictive, but to give organizations more guidance on what they can use to support their activities. Because we had gotten some comments that, well, discussion had gone both ways. One was, should you list more specific data sources? Like we had talked previously about, like the State Bar's Justice Gap study and whether organizations should use data from that. But, you know, there had been discussion about how current that information is and whether you can get something more current or more detailed. So moved away from using specific or itemized sources of data. But we'd also gotten feedback from the legal aid community both ways. Some wanted sort of broad categories of data, and some said that they didn't like that the proposed rule listed potential sources or potential options for justifying the work, and felt that that was not necessary. Given that there's enough, I think, confusion in the community about, you know, what is necessary to support the activity, like what level of research or detail needs to be provided in order for this to be considered qualifying, it seemed more appropriate to give those examples and let organizations kind of work within their means to find ways to support the activity. But I did want to note that there was feedback, at least from a small contingent that in the community that didn't like sort of adding that list of possible sources. So Selena, I don't know if you had anything else you wanted to mention on that.
Well, no, I have a question, so I'll wait until after Pamela.
Pamela, did you want to ask your question or do you have a comment?
Yeah, I just had a quick question on the from page 29 and number 3. So the indigent are at a disadvantage financially. So where is the disproportionate piece coming in, or is it just the language? They're already at a disadvantage by being considered indigent, and so I was trying to figure out where that disproportionate piece of work comes in.
Yeah, so some advocacy activities, for example, might not only impact indigent persons, like if you're trying to get a bill passed, that could have an impact on, you know, entire portions of the population throughout the state. You might not be able to show that a majority of those individuals are indigent, but depending on the nature of the activity, you might say, well, if this bill gets passed, it's going to have a huge advantage or benefit for indigent persons. It's really going to support indigent persons or help them in some way. And so that's where the disproportionate impact piece comes in. I think an example, actually, I don't know if it was in the letter or from a separate conversation, but I think an example that maybe public advocates have provided in their letter was, you know, if you are doing advocacy around, you know, parking restrictions and cars getting towed, and, you know, anybody who gets their car towed, that is an imposition, it is a difficulty, it's a challenge. But for some individuals, it may be something that they can get past. And for some individuals, if somebody's indigent and let's say they're unhoused and they're using their their car as a living space as well, that's a much bigger impact on that person than somebody who only uses the car for, you know, errands or for going to work. So that's where I think they highlighted those situations where advocacy on a particular activity on its face might impact everybody or a very big portion of the population. But if you achieve your goal in getting a certain bill passed or amendments made, that it would have a disproportionate or a larger impact to indigent persons. That's where that piece comes in.
And I think my question, Erica, which I think I've brought this up the last time we talked about this, is just, I know that this is a lot of State Bar staff time to read the 1,000 reports that you had to read last year. And I'm just really curious about how we set the oversight to make sure that you are capturing the work that is likely to be non-qualifying, but not asking for such a volume of reports that you're reading through when the likelihood of capturing that's not qualifying is so low. Like, is there a way to better target like types of work that isn't likely to be qualifying? And so that's just a question for State Bar staff, is if there's potentially another way besides the iLaw reports through spot monitoring or something else to get the type of work that's not qualifying, and not just, I hear complaints about how much time it takes them to fill out these reports that you then have to read, of like, how can we make this more efficient for everyone?
Yeah, so I think part of it is, the committee spoke last week about like the definition of legal services, civil legal services. So a lot of these activities, it's not just focused on the piece about serving indigent persons, but is it civil legal services? And so I think clarifying what is legal services and what's not, and having that great kind of outline that was discussed at the last meeting, I think that's going to go a long way in terms of what would be considered, like clarifying what's qualifying and what's not in terms of a legal service. And I think that's what a lot of, in prior examples I'm thinking of where there has been an issue, sometimes that has been the question is this a legal service? Like I think we had previously, maybe 2 years ago, discussed like census work or census outreach. Is that a legal service? So I think there's that piece. But I know that's not necessarily going to reduce the reporting, but I think it would make it much easier to clarify, like without needing follow-up or needing to take up committee time or additional staff time in terms of understanding whether it's a qualifying activity.
Erica, can I add something?
Yeah.
Also, and this is one of the reasons why our recommendation is moved to a 3-year cycle and couple it with the monitoring visit, because that's when we can do kind of a deep dive. And like Erica is saying, it's not just this issue of what is indigency, but the legal services. And I think we've come a long way in the last few years. So we rolled out the iLaw report in like 2018, 2019, in response to the recognition that the office wasn't treating programs kind of equally. There were some programs that had to report all their activities, like Catherine just mentioned, some of our larger programs. And then there were programs that we never required to report anything. And that's why we rolled out the iLaw report to treat programs fairly and be consistent. But I think the pendulum did swing too much the other way, because this has been a very kind of heavy lift. Just to give you a sense of kind of staffing time, we have between 6 and 8 staff that work on iLaw reports for the span of 2 months. When this comes in, it's an incredible amount of work on programs. And when we first rolled it out, those 2 or 3 years, we did elevate a lot of issues, and that's because that was, there was uncertainty of what really was qualifying But since we've kind of launched the codification process, it's given a lot of clarity. So programs like Erica mentioned, a lot of the programs, a lot of the activities that are non-qualified, it's self-reported. So really, there's only a handful that gets elevated to the committee every year, and within that handful, every year it's like less than 10, maybe even less than 5 activities that actually go are a little bit more controversial in the program, and I agree. So we think that's why moving it to a 3-year cycle makes sense. Will we catch everything on a 3-year cycle? Probably not, but even now we might not, but I think that gets us closer. So it's like on balance, right? Given the amount of staff hours, the amount of, program hours, and also with the rules revision process that has given it more clarity. We just think moving to a 3-year cycle just makes the most sense at this point. Jim? Oh, you're on mute, Jim.
To follow up on this point, only 6.5% of the impact litigation activities were denied, and only 2.4% of the advocacy were denied. Do you have any metrics on those that were denied that shows how different they were from all the ones that are approved? I mean, instead of looking at this in terms of number of hours that a program does or the number of activities that they do, what about trying to pick out a way to measure what's routinely being denied, that small number, and can those be spotted ahead of time as opposed to reviewing all the projects?
Yeah, I don't know what you mean by metrics, but I know like anecdotally in the last few years, I mean, they're the ones that are like the newer activities, right? Like we just haven't come down on. So, you know, we have the voting rights, the census work, but now that programs know, you know, it'll be a lot easier. And I think what we could do maybe a better job at is like advertising, I guess. The programs that do that work now know that like that they got elevated, and now that we found them next year, it's probably not going to be an issue again. But I don't know if we have done a great job like circulating that to all programs. So perhaps we could do a better job of that. But I don't know what you mean by metrics, like in terms of common like features.
Common features, population served, those kinds of things. The other thing I would suggest, if we have the 3-year cycle, I can understand why you'd want to do that, but have another layer so that if during the 3-year cycle review, if you spot X number that were improper, then that program for the next 3 years maybe ought to report yearly.
Oh,
So,
yeah, you can always do something like that. And, you know, and I know I got this question from Selena. So every 3 years doesn't mean that's the only time. So sometimes a program will of their own like volition come to us and say, hey, we're about to like partake in this litigation or this advocacy activity. We know it's gonna be a lot of hours. Can we get an opinion from the commission? And in those cases, like the few times it's happened that we have, I mean, we can't call a meeting especially, but what we can do is roll it into kind of the next eligibility and budget review. So not waiting 3 years, right, to make a determination that they've already invested all this time, and then we find out it's not, and then they have to undo. So we can help them along. I think most programs, they're very honest. They come to us and they ask us kind of a thing. And then of course we have the subset that they honestly thought that it was qualifying and the commission determines that it's not. And so we think that the 3-year will catch the majority of it. But common features though, Erica, that's an interesting, I don't know if it's coming, to me, it's not jumping out, common features for any of the ones that we have found non-qualifying in the last few years, but I don't know for you.
No, I mean, I think the activities were one, like I said, census, voting rights was another one. There was also discussion, which actually the organization wound up voluntarily making it non-qualifying, but like about out-of-state work for as far as QLSPs are concerned. So those are the top 3 I can think of, like those types of categories. But I do think, like, you know, the census was obviously given that the decennial census was happening. So that's not going to be like an every year type of thing. But yeah, I unfortunately can't think of like especially for the ones where the organization's voluntarily deducted. I don't think we necessarily track like what is the theme for the organizations that voluntarily weren't non-qualifying. So maybe we could look at that piece for the ones that, even if it didn't go through eligibility and budget review because the organization was in agreement, you know, kind of if there is a common thread there. I don't know right now. I could look into it.
And Will, I think you had your hand up, and then Catherine.
Yeah, I think what I'm hearing here is we want to do a sampling, right? We're trying to decide whether we want to sample less deep every year or do a deeper sample of the work they're doing every 3 years. If that context is correct, then I think going deeper in our analysis is wise every 3 years, if that's the availability that we have. And I think also basing it on a percentage, as Catherine suggested, of hours, so that the depth is actually there. We aren't arbitrarily at just 25 activity reports when they're doing a lot more that then doesn't get captured. I think I would support that. But I have to admit, like, all of this sounds like it could be handled more easily by just asking programs to get pre-clearance before they start on a program that's going to have a lot of hours.
Well, it's also, there's a lot of activities, Will, across. So I I would hesitate requiring pre-clearance when some of this can be programs have been really good about self-executing the definition.
Oh, yeah.
And
Oh,
that's why
sorry, I
we
meant
yeah.
pre-clearance on novel questions, right? Once a program or it's been, you have a list, you say, okay, these are okay, these are okay, these are okay. But if it's new, it's novel, and we haven't distributed like a rule or informal rule or office practice or whatever, then I think it'd be easy to just say, hey, programs, please call us, because doing it after the fact seems like it's harmful to everybody if they find out it was in fact ineligible. I'm not sure if that has to be a part of the rule, but
Oh yeah, I think you're right. We probably could send out an email, maybe a yearly email saying, a reminder saying, if you're thinking about partaking in and you like, this is kind of the meeting where we can kind of group them together and bring it to, I think we could, that's probably easy enough to do, right, Erica? As a reminder, but not having in a rule, but like that, we do that anyways, but just reminding that can be part of the process.
Yeah, I just don't want people to be surprised,
Yeah.
right? That's the negative.
Catherine?
So I think one thing I might not be understanding is if we go to a every 3-year cycle and the program, and you find something that was unqualified and it had existed for the 2 years prior to the year in which it was discovered, what happens with that then? Is it only are programs then required to go back, look backwards because it was a large sum of money that shouldn't have qualified and reimburse the trust fund for that? I mean, what's the...
I don't think that's what I was envisioning. And Erica, you can chime in, but I was thinking for that current application that's coming up, then they would deduct, but it would be too hard to open up and reallocate money and roll back from like previous. So it's only for the current cycle that would be upcoming application, I should say. So depending on when they're monitoring, because it falls in the year, right?
The example Erica gave, which was a large program that does a lot of systemic litigation, was about, we're going to do a case in New York, and when that case is successful, it's going to be a good precedent, and we're now going to bring that case in California, and we want to count, and they were proposing to count, and they identified it as in the, I think the ILAW report, as work that they were going to do. And then ultimately was determined like, no, that your exception to that, if it's ultimately going to benefit Californians, is not accurate. But I guess it troubles me a little bit, like you lose the ability to see a large expenditure in the first 2 years when it's happening. They get to count that money as a qualified expenditure to the detriment of other programs. And then in the 3rd year, you say, don't do that and don't report it in a subsequent year, where it could be even a smaller amount of money at that point. So I don't know, it feels like there's, like, if I'm looking at this from the legislature's perspective of, is the trust fund commission making sure that expenditures are for qualified expenses? I don't think I'm comfortable. Like, there's no, like, you will in fact have now discovered that there's potentially large expenditures made in the prior 2 years that counted as qualified, and there's nothing you can do about it. So that just leaves me in a place, given the large amount of legislative oversight, that's the climate we seem to be in, like maybe not the best place for the commission and honestly programs to end up.
Yeah, I mean, I see your point. It's so much work, Catherine. I can't underscore how much it is, and what we find every year, because you're on eligibility, isn't that many cases or activities. That's what we're trying to balance. So
yeah, that's why I think a much smaller report where you could just quickly look at it and say, yeah, no problem, no problem. And then for things that look like they were potential problems, that you would then ask for more information at that point.
I mean, I think in theory, we probably could shave down that report a little bit, maybe 25%, maybe 30%, but I think having the onus on staff to go back and collect more information might even create more work for us in a attempt to kind of streamline, because I think the first, and Erica, Crystal, you let me know, and I just reviewed it too myself this year. I think it's those first 6 questions we need, and then like there's some narrative questions, and within that, maybe some of those you don't need. But I don't think we're gonna be able to like reduce it down, like shrink it like 25%. We might reduce it some, but I don't know how helpful that's gonna be. It'll be helpful, it's still gonna be a lot of work. And if that's what obviously the commission determines is needed to fulfill your oversight responsibilities, then obviously we will execute.
Yeah, I guess I'm trying to figure out other ways to get to the place. So I'm not trying to burden
Yeah, no, of
staff,
course.
and I appreciate the burden of it. So I guess my discomfort is not having information for 3 years and not and having it play out badly where there's a large amount that is unqualified
Okay.
that you didn't know about. So that
Sure.
from my perspective, if that's a risk, I think that maybe not worth taking, then I think it leaves us with something that's going to work on an annual basis. I
Yeah,
guess.
no, I hear you. Then maybe it's about shrinking the annual report, not just like the report itself, but this threshold that you were talking about. And maybe that's the way we go. It's just, I do want to remind everyone, like before this iLive report, and when we rolled it out, we didn't actually have commissioner approval. We just did it because that was per the codification process. Like I said, there were only like 10 programs that submitted, and the other ones we never asked for it. So it did. Now we're asking for everything. I'm just saying there was a point that for the vast majority of programs, we're not reporting anything. So I think I don't think we need this level of information, these thousands and thousands of reports and thousands of pages.
Yeah, so I no disagreement with that point. It's just, I guess in my head, I've landed like the downsides for 3 years are too much. I would like us to focus on what
I
can
hear
we
you on
do
that.
every year that's gonna let us get quality information that like is meaningful to look at, and looks like we've done annual due diligence. That's all.
No, absolutely, I hear you. I think Jim, you're next, and Selena.
Yeah, I was just to handle that observation. That's why I think we need sort of a 2-tier. That is, if during the 3-year review you find some that don't qualify, then the subsequent 3 years or maybe 6 years, they have to report annually. So that there's a disincentive for them to do something that's borderline without getting pre-clearance, because they know they're going to be reviewed every year instead of every 3 years. And I think having something like that in place would discourage people or programs from sort of skirting on the gray areas and trying to get programs in because they think they won't be caught until every 3 years.
Selena, and then Will.
Well, I definitely hear Catherine's concern, because we want to make sure that we're not using California IOLTA dollars for non-California work. And I wonder if there's a different threshold for the yearly reports of looking specifically at the type of things you found non-qualifying in the past. Like saying if there is litigation outside California that they plan to use IOLTA, they want to use IOLTA funding for, then they're required to report on that. Like I feel like there's got to be a threshold based on the past years of y'all catching some things of saying, if you're doing this, ask us first. Or if you're doing this, you must report annually, to go to Jim's point. Or like, Dwan, I know you've said before that if programs have questions, they should just ask before they engage in the work. Like maybe we can message that better. And then on the front end, fix it before IOLTA expenditures are used for non-qualifying work.
Yeah. Well,
I have, I think it actually might be useful to have a line in the rules that say programs may call to get clarification on whether it would be a qualified expenditure. But my question is, how much money are we talking about? Like in a budget for a program, like, is this $20,000 or are we talking about $500,000? Like,
no, it really depends. I think that the census and voting rights, that was pretty large, right? Erica, that was, if I recall,
Probably
in the thousands of hours.
100 hours or 1,000, something like that.
1,000 hours, something like that. It was meaningful amount. It wasn't just like a 50-hour activity.
right. So yeah, I guess that might be another place where we could just say, if you're about to start a program, that is going to be 1,000 hours, get pre-clearance, instead of trying to do it after the fact and having to worry. But I guess I also realized that trying to think all of this through during this meeting, when we also have another topic, and I had a few other items just on this rule that I wanted to
Yeah,
get answered.
that's a good time, check for time. And I just really want to encourage us, if possible, to wrap something up on this topic. It's been a year and a half, and this is the other thing. I think I mentioned this at the last Rules Committee meeting. I really would like to get the grouping, civil legal services, Erica's topic, indigency, and the topic that's going to go next that Crystal is going to present, present to that, next week's commission meeting, because that's the only way we can make it in time for the board's November meeting, where they do rulemaking. If we don't make that November meeting, we have to wait until May. So it's going to delay another 6 months. And this is the
call
third
a
time.
special meeting,
Excuse me?
or we could call a special meeting to just deal with this.
The commission is really stretched. I don't want to speak on behalf, but my sense, we already have to call a December meeting to deal with consumer debt legal assistance. I don't know if the commission.
And you're trying to plan around the BOT meeting, not
we're
just
trying
the
to plan
Transport Commission.
Yeah. So there's lots of moving pieces, and we've done really great work on the Rules Committee, but we haven't had an opportunity yet to take it to the board to then send out for public comment and get some of these like on paper. And programs have been asking me. I mean, I get probably an email either directly from Selena or a program pretty regularly about, hey, you talked about that topic in whatever meeting. Is it rolled out? Yeah, and it hasn't even gone out for public comment officially for anything. So I really encourage us to try to move.
Do we need the Board of Trustees approval if we just go to example number 1? Because is that like a major rules change, or could that be just something that the commission does for 2023 as we keep investigating how best to capture?
How's it drafted right now, Erica? Is that actually a state bar rule that would affect this change, or?
Yes, it would create a new state bar rule.
Yeah. Jim?
Yeah, I just to pick up on Catherine's and Will's point. What about having a rule that says if your proposed impact or advocacy work is going to take up more than 10% of your staff time, you should get pre-approval?
I'm going to say, like, from my experience, like, that would be for every piece of impact litigation. And what is pre-approval for? Like, that you can use BARFA? I don't know. To me, that pre-approval would be a lot of work, because DRC, at least when I was there, engaged in hundreds of pieces of significant litigation. And I would call Dwan weekly to say, now we're doing this. And she's like, put it in writing and explain it to me. And I don't know, that seems like more work. I kind of like Selena's. I mean, like, I feel like I can live with some version of like report it annually. Maybe it's, if you only want 10, fine. I just think it has a disproportionate impact on small programs. So I kind of feel sorry for them, but that's okay. I mean, 10 for DRC would be cutting by more than half what they currently report to you.
Yeah, but just reporting 10 doesn't cover the situation you were concerned about. What about the 11th one is going to be out of state?
Yes, and I guess I feel like, I think it should be based on some percentage of the work you're doing. Like, so at least you could say you did a reasonable sample of that program's work and they reported it.
Well, I think what Catherine, what you said that resonated with me is like being in a position of, if we actually did find something unqualified, but we didn't modify it back 2 years, I think that does leave us exposed. Whereas if we set the standard, whatever it is, at 10 activities, then, I don't think it exposes us. And then that's still, I think that would, you would still be doing your due diligence, and staff would be too. That feels more comfortable, at least from my perspective. Erica, what do you think?
Yeah, I think having an every year reporting requirement, but reducing the burden would be appropriate. I like Catherine's suggestion about, if you could find some way to make it proportional to the organization's work performed rather than just having a straight line cutoff at 10, that would be helpful, but I don't know if in today's meeting we would, be able to come up with that kind of, step up type scheme, but.
Yeah, what about combining the two? That is, the routine one would be every 3 years, and if anything is found unqualifying in the 3 year, then you have to go to example 1 where you report 10 activities every year.
I think you have to have a way to recapture the money that was wrongfully spent. I honestly do. I think about this from, this happens, it was $750,000 spent over 2 years, which would not be impossible in a big piece of litigation. And the LA Times runs a story about that, and there was no oversight.
Yeah, I think you convinced me, Catherine. I mean, we do a year and then we land on what the activity and the number of activities. So
Well, that's how, I
but if
mean,
you have
maybe that's like what the rule is. You do it in the, I don't know, like you need a rule now. So like, whatever, I don't know. I just think you need something every year.
If you're doing a very big program and you say 10 activities, only those above 50 hours, and you've got 20 activities that qualify, you pick the ones that are least problematic, and you're
Yeah, but
still
I
not going
think
to cover that.
no, I think you say, like, my understanding of the rule was it's above 50 hours and choose the ones with the highest number of hours. That's how I always reported, and that's what I understood the rule to be. And that seems reasonable because you want to capture the things that have the potential for the highest amount of unqualified expenditures.
It doesn't say that. I mean, you'd have to modify.
I'm saying what I would make it, like, right? It's different to say like, it's things above 50. I thought the current rule was 100, but it doesn't really matter. Things above 50 hours. And it's whatever the number is, and you choose those things that had the largest number of hours attached to them, because that's the risk is.
That is what the proposal says. I was paraphrasing here, but yes, in the attachment that you all reviewed, it is based on highest number, like working backwards from highest to lowest.
And we're talking about staff hours, not pro bono hours.
Right. Yeah.
Yeah.
Because
I agree with that.
The pro bono hours don't actually go into their qualified expenditures, so.
So for the sake of time, because we've got another substantive topic at the agenda, should we start kind of getting into what the resolution would look like and what we'll want to actually put forth to consider and vote on?
I had some small items and 2 other items that we haven't discussed that I could run through very quickly. But yes, I would love to see a motion up or the rule up so we can see the actual text we'll be voting on. I think if the report is done, that would be great.
Yeah, the only last thing I was going to mention was that there is also an inclusion of working with organizational clients, which is in the eligibility guidelines, but hadn't been incorporated in the proposed rule until now. It kind of fits in with ILA, but it's one more step removed from working on behalf of a group in terms of working on behalf of an organization that represents indigent persons. So basically the proposal tracks what's in the eligibility guidelines currently, which is that the organization would need to essentially demonstrate that it provides benefit to, its purpose is to serve indigent persons in order for the work on behalf of an organization such as a nonprofit to be qualifying. So let me pull up the
So if I can continue, I will start with my first comment on the ILA piece. This is kind of a zoom out, and forgive my unfamiliarity with how the ILA stuff usually works, but on the litigation piece, my understanding is there's professional standards and there's a duty, and that kind of covers the outcomes there. Everybody has to meet that standard. But with the advocacy part, it seems like we are allowing potentially a lot of money where we don't keep track of the outcomes, and we don't have the built-in requirement that there of a duty to perform those services professionally, and that we're going to make sure that there's actually a positive impact for the money that gets spent on the advocacy side. I'm obviously not familiar with a lot of how these programs probably spend that money, or whether it's a lot, but I would propose adding a section where we require a report on the analysis of the advocacy activities. Something along the lines of, when submitting a report required under this section, the organization must include an analysis on how their past advocacy activities have improved the quality or accessibility of legal services, or otherwise helped indigent clients effectively assert their legal rights, or improve the regulatory environment so they have less need to access legal services. So that we don't, oops, I didn't turn off my video, I didn't mean to. So that we don't require that we know best, you know, but that we do keep track of outcomes. That would be a motion I would like to, and I know it's another reporting requirement, but if we don't keep track of the outcomes for advocacy, I'm concerned that we lose a little bit of the accountability that we get for free when people are providing direct legal services and conducting the IL part of ILAW. But
So,
if I don't have
so
a
Will,
second on
there's-
that.
yeah,
I'll
no,
move on.
well, thanks for that comment. And I think, and I'm not 100% sure about this, but I think that is addressed in some of the reporting.
Oh, it is?
That's done, but
Cool.
But I think we might be kind of getting a little bit out of order because Erica was going to jump into the text of the last piece, the organizational work on behalf of organizational clients, I think, to present that to us, and then we can start getting into the particular text of what might be before us for a vote.
Thank
so,
you.
Yeah. So
Go ahead.
Erica, go ahead.
Oh, sure. So, as I was saying, when legal services providers provide services to organizational clients, the eligibility guidelines currently have these factors included in order for it to be considered work on behalf of indigent persons, because they're representing the organization instead of, you know, individuals. So basically what appears as subsection E in the proposed rule tracks very closely to the language that's in the current eligibility guideline about providing services to organizational clients. So, you know, it will include an analysis of whether it's a nonprofit organization, the organization's primary purpose, you know, whether it's intended to serve indigent persons, the number of percentage of indigent persons on the board or any principal advisory body, and then of course, the percentage of the organization's clients who would be considered indigent. So it's really just kind of, like I said, tracking that language, carrying it over from the eligibility guidelines into a proposed rule as we kind of move away from reliance on the guidelines themselves. Then, so I had gone over this before, the additional language added for the pro bono allocation that was highlighted before. Some of these other changes were just to clarify. So like when we originally had gone over a proposed rule, the change to 200% of the federal poverty level had not been approved yet. So that's just been incorporated here. And then, yeah, subsection F is the section that deals with ILAW reporting specifically for qualified legal services projects. So as I had mentioned before, this first subsection is really kind of the crux of what the committee was discussing before in terms of where to draw the line in terms of how frequently you should report or what are the number of reports. And we can wordsmith that a little bit. And then subsections 2 and 3 just get to demonstrating indigency, as I was saying before. So subsection 2 is saying that, you know, if they have to complete this reporting requirement, that they would demonstrate through objective information that a majority of persons impacted are indigent. And then it gives that list of acceptable ways of demonstrating that, whether it's through independent research, their own internal data, community-based data, etc. Subsection 3 sort of establishes or clarifies that if you can't show that a majority impacted are indigent, then you can move on to section 3. And it basically says that, you know, you would then be looking to demonstrate that the activity has disproportionate impact based on the nature, a description of the nature of the activity and the specific anticipated outcomes for indigent persons if the activity were to succeed. And then similarly, just as with a majority of indigent persons, if you're showing disproportionate impact, you would need to do that through, you know, independent research or internal data or community level information that's available. So I think it sounded like, if I understood correctly, that folks want to move away from the 3-year option, so I can just delete that if we're not going to be considering that, and then focus on sort of what parameters you want to put around the 1 year, like every year reporting.
Yeah, I think that's what I heard too, Erica, so.
So not sure what particular changes you'd like to make at this point.
Catherine, did you have a suggestion? Because you said it was something, and I'm not recalling right now. 10 or, I mean, to address the size of the. Catherine might not
I don't know, is it like the luck? I don't know enough for sure about how many activities there are, but it could be like the larger of 10 or 10% or something like that. Like, I just don't know whether that, I just don't know. I mean, I don't know if we have data that I could base a reasonable percent on, right? But
Yeah, the current eligibility guidelines actually only, like I said, we don't enforce that provision, but they do say you only report if it's above 10%. So that would kind of be consistent with, you know, 10 activities or 10%.
is there any way to do a rule where, I don't know, like, can the trust fund commission set what the standard is going to be each year? Does that make any sense? Like, do you know enough to, like, it's 10 or a higher threshold set by the trust fund commission on a annual basis? I don't know. I'm fine with 10%. I'm relieved to have it be annual.
Yeah, I mean, I don't see why you couldn't do it, but I feel like you shouldn't do that because every year we're gonna have to revisit it.
Or you could say, or unless the trust fund commission sets a higher threshold, then you wouldn't have to revisit it. But if you saw sort of a pattern, then like you could.
Yeah, maybe that's a way.
I sort of feel like the difference between 25 and 10 is going to tell you something about what used to be reported and what you're getting now. And maybe it will be just fine under the, you know, programs want to be above board and tell you what's going on. But maybe there's some flexibility for saying, unless the trust fund commission sets a higher threshold, that would allow, if there was a problem, to without having to go back and get a whole new rule revised to set a threshold. So maybe that's better than a percent.
I think that's fine. Brady, that's fine, right? If we put that, unless it's like 10 activities, unless, you know, the trust fund commission determines a higher. Can we do that in the rule? Yeah, right.
And I know we're going to be voting on this motion, but I still remain committed to figuring out ways to, like, on the front end, educate programs about what is likely to not qualify, like maybe an FAQ, and LAC would be happy to help programs understand that it's just easier if they, you know, only count what is likely to be qualifying, and if it's not likely to be qualifying.
So I think what we should do is, you know, Chris's topic last week on civil legal services, within that memo had a chart. We start building out that chart to include, you know, topics, Indigency topic, like, you know, other topics too, not just civil legal services that's qualifying and not qualifying.
The reason why I just think this is so important is I think that there are larger, sophisticated programs that can make their case really well about what could be qualifying if it's on the fence, but programs that are kind of less sophisticated in that messaging may be undercounting qualifying work or not realizing it should be qualifying. And so the more transparency, the better for program equity, but also for State Bar staff time too.
Yeah, no, I think that's right. And I have to admit, I don't think we've done a good job at messaging. Like, we didn't like send out an email and an advisory saying, you know, now voting rights. I think we just have yeah, take for granted that is understood generally. But yeah, I think there could be.
Oh, I'm comfortable with that addition, Dawn. I think that's fair.
Okay.
And did we, Will, does this adequately address the issue you raised about getting outcome data on other activities, or?
I would say it's very focused on, are we providing legal work, and not whether the advocacy has been successful.
Yeah, so I can speak to that a little bit. The current report does say, like, if you have completed the activity, what were the outcomes, or how did this, you know, impact indigent person? So it does ask for that sort of summary.
Perfect. Okay. Then yeah.
A lot of the activities are ongoing, so they might not actually have something listed in that section of the report currently until it's completed, but it does ask them for.
Yeah.
That is really excellent to hear. I really appreciate it.
So maybe we can work with the Eligibility and Budget Review Committee to determine what they like to see, because that would be one of the questions that would be up maybe in consideration of, like, if we wanted to streamline taking out. So yeah, I think eligibility probably it should go through eligibility then to take a review, because they know what they need to make determinations.
Yeah, I think that would be really helpful in making sure that we maintain that accountability without overburdening the programs. Should I run through, is this the appropriate time to run through the small questions I had? Sorry, I didn't.
Because we do want to leave probably an hour, 45 minutes for Crystal's topic, probably an hour.
I think most of these will take 5 minutes, and one might take another 5 minutes. So I want to be really quick, but just in section E there, so up above F, I just wanted to make sure that everyone was aware that not all tax-exempt nonprofit corporations need be charitable. And as written, we might be including more than we intended. And it also states that the nonprofits need to have a purpose, but not what that purpose is.
Those are factors to be considered, so it's not being.
Maybe I just don't understand, how it's to be read.
Yeah, so it would essentially say that, like, organizational clients are subject to review in terms of whether they would be considered qualifying or not. And these are the factors that would be taken into consideration about. So nonprofit is not dispositive, but that's one aspect you would look at. You would look at their primary purpose stated in their bylaws about, like, why was this organization created, or what is their main function? You know, is it to serve indigent persons, or is it to do something else? You know, similarly, like the fourth factor being the percentage of clients who are indigent. And so whether, even if their bylaws say it, are they actually consistent with that, you know? But it's not intended.
Okay, I guess I read it.
Hit every point, or if you don't hit every point, then, you know.
As a checklist, if you hit all these points, then it's okay. But you're just saying it's just factors, and it's still, these are advisory factors.
Yeah, I mean, as it stands right now in the current guidelines, it says you need to report out on specific organizational clients if it exceeds 10% of your services.
Got it.
Anecdotally, when I have followed up with organizations to ask this question, because I have seen them report that they are serving organizations, they're often saying it's anywhere between 5 and 9%. So
Okay.
we actually don't get a lot of individual reporting on this. So I guess that would be one change. This doesn't necessarily limit it. It just is saying that this is the requirements for, this isn't a reporting requirement. It's saying these are the standards you need to look at when you're considering taking on an organizational client in order to, if you were asked to demonstrate that that's qualifying work.
Okay.
Should we make it like more of an included but not limited to?
Mm-hmm.
Or are those that like maybe factors to be considered in determining include but are not limited to at the end?
Mhm.
And then that probably makes clear, Will, that it's
Yeah.
yeah.
Yeah, absolutely. Okay. And then the other section was B, section B, where public advocacy asked about getting clarity for youth eligibility, client eligibility. And I don't know how it's currently handled, but to me, it seems like we should have a rule that says if you are, you live in a house that's household that is ineligible, but you don't have access to that money because you're a child and you'll be kicked out of your home, or you're a spouse that's has the threat of violence, or you're a trafficked individual, or any number of the horrible situations that arise, that we could include them
Yeah.
as being eligible directly.
Yeah, so I think that goes to subsection D, which talks about eligibility guidelines and income exceptions.
Okay.
So, organizations establish their own guidelines for income screening. And this new subsection, which had been approved previously at a prior meeting, which is why it's not in track changes, was, their income guidelines can include provisions to allow them to disregard income or make income exceptions in certain extenuating circumstances, including but not limited to, and the example given was intimate partner violence, but I think also if you were talking about a young person who, may not have access to income that might be held by their parents or something like that, that might also be a circumstance where the organization is going to make an exception, even if they're living in a household, that they don't have that type of access to, the income, so it wouldn't be considered, they might draw those lines, but it's not meant to be prescriptive.
Okay, I guess as long as we're not limiting people or rejecting people, or organizations, QLSPs aren't rejecting people because, well, your household has the money, you can't access it. I think that is what I want to make sure that we are making really clear to organizations that they can, and that those should be qualified expenditures.
And we've always let programs do that. It's just now obviously codifying that practice. So that, yeah.
Awesome. That's all I had. And thank you for educating me on these pieces, because they're personal, close to my heart. Thank you. So now we need to make a motion to recommend this rule to the commission.
Yeah, the recommended motion would be for the committee to approve the proposed language to define and demonstrate indigency as discussed and recorded at this meeting since we made changes.
I'm happy to make that motion.
Catherine will second.
I'll do roll call. Excuse me. Sorry. Al-Saraf,
Yes.
Fight Master Bennett. Pamela, are you still there?
I
Pamela?
think she dropped off.
She dropped out.
No, she's there. What?
Pamela, can you hear us?
Yeah.
Blakemore,
Yes.
Boshelli,
Yes.
Connolly, Meeker,
Yes.
motion passes. Oh, Pamela, sorry, did you mean to vote? Pamela? Okay. I'll turn it back to you.
Okay. Sorry, Pamela, it's really, it's kind of hard to hear you. I'm not sure what's happening. There might be a connection issue. So, and I don't think we have a chat feature. So I think the motion passes because we have quorum notwithstanding. So why don't we move on to the next item? First of all, thank you for that, to everyone for that discussion and for getting to, and for Erica and the working group for getting that all together and running through a pretty significant issue and getting through the substance. Let's move on now to Crystal on the next topic, and we have about an hour until hopefully we can get through this as well. Go ahead.
Great, thanks, Amin. I can go ahead and get started. Can everyone hear me okay? Okay, I'm gonna assume so.
Yes.
Okay, thank you. So this is the second item for today's agenda. Item 3B, approval of recommendations related to the primary purpose requirement. The working group comprised of Corey, Rich, and Judge Seligman. I think I saw Rich pop in, so Judge Rich, feel free to chime in, but I'll provide an overview regarding the working group's recommendations. Governing authorities related to this topic are Business and Professions Code Section 6213, State Bar Rule 3.671 regarding primary purpose and function. Just grabbing a quick quote from their Qualified Legal Services Project is required by statute to have as its primary purpose and function providing legal services without charge to indigent persons. And then also related, the Legal Service Trust Fund Program eligibility guidelines for legal services projects 2.3.5. There were three main codification issues identified under the primary purpose topic related to qualified legal services projects, and they're as follows. One, whether the commission should codify current office practice. Let me hide my screen. Of using QLSP's expenditures from its prior fiscal year to determine primary purpose. Whether the 75% of qualified expenditures presumption for satisfying primary purpose requirement under State Bar Rule 3.671 should be changed, and whether the commission should retain discretion to find QLSPs eligible by the any other means test under State Bar Rule 3.671C. One thing I just wanted to note, I think unlike the prior topic that was discussed, we're actually looking at refining the current rules, not necessarily changing them, so that they conform with office practice and also take into consideration some recent legislative updates which have impacted the State Bar's grant administration processes. Just a reminder of this timeline. This topic has actually been discussed over a period of time, starting in March 6th when we previewed the topic. In September, we gathered legal aid community feedback on the working group's preliminary recommendations. Those were presented in October 4th, 2020. And then during the period of October 2020 through July 2022, again, there's been various updates, which I'll cover in the next slide. You all had the July 29 Rules Committee meeting to discuss the definition of civil legal services, which was a primary reason why there were no votes made at the October meeting. In July, the working group reconvened and updated its recommendations, and then we gathered recent community feedback on those recommendations end of July, which we're presenting to you today for hopefully a vote. As Juan mentioned, we're looking to group this topic along with indigency and definition of civil legal services at the August 12th Commission meeting for approval at the Board of Trustees meeting in November 2022. The memo for this item highlights 3 significant updates since the committee last discussed this topic. Update 1, and Erica also covered a couple of these points as well, hence the overlapping of issues. Update 1 is that there's expanded income eligibility for legal services projects under SB 498. That changed the income threshold eligibility from 125% to 200% of the federal poverty level. And then also veteran disability compensation should be deducted from a client's income when determining eligibility. Update 2, the IOTA statute was updated to include expungement work under SB 211. So they're now included under the definition of civil legal services. And update 3, this was sort of what we were on hold for, is the discussion of the proposed updates to the definition of civil legal services. This is a pending codification topic, which I think maybe is less pending as of last week, but that working group recommendation was for a more expansive definition to include complementary services and professionals, as you all know. Items for issues 1 and 3 that I mentioned earlier, those are straightforward. Much of today's presentation will be on number 2, but 1 and 3, the community was in favor of, and the working group did not change or update its recommendations, but I'll go to give a quick overview. Topic 1 was the fiscal year for qualified expenditures calculations. As it currently, under State Bar Rule 3.671, it requires an organization's proposed budgets for the coming year and the organization's expenditures in its most recent fiscal year to demonstrate primary purpose. When you consider current office practice, we actually only look at the percentage of expenditures only from the most reporting period, and then organizations are not asked to submit budget information until after they're found eligible by the commission. The working group just wanted to streamline this and codify office practice by deleting reference to calculating primary purpose based on budget information for the coming grant year. You'll see that in the red line edits in attachment A, but this is more of an administrative update so that the rule reflects current office practice. Okay, so the second issue identified was the 75% qualified expenditures threshold for primary purpose. Again, under State Bar Rule 3.671A and those eligibility guidelines, QLSPs are presumed to meet primary purpose if 75% or more of its budget and expenditures is designated to provide free legal services. Currently, staff elevates any applicants or QLSPs with less than 75% of qualified expenditures to the Eligibility and Budget Review Committee. There's also an informal guidelines that QLSPs who report below 50% do not meet primary purpose. This chart below is also pulled from the memo just to get a sense of the actual number of QLSPs who are impacted and who have reported below 75% and hence elevated. So you see a range of 3 to 7. We're also noting that you saw a higher QE percentage range for those for the 2023 IELTS EF application year, which is 62 to 70%. And then, as you might note, there's a really low percentage at 13%, but that applicant organization was found ineligible for the 2022 grant year. Generally, the Commission has accepted explanations from applicants with qualified expenditures of more than 50% and found that they meet primary purpose. Some typical reasons are listed below. For example, a QLSP might have experienced an anomalous yet significant event resulting in a one-time dip in qualified expenditures, but has shown in the past that they've consistently reported at least 75% in prior grant years. Bullet point 2 is that the QLSP offers an integrated service delivery model and then falls below the presumption threshold because it's deducted for work or positions that do not fall under the current definition of legal services. To note, this was a pretty big point considering the topic that was discussed last week. It may not be a relevant scenario now. And then bullet point 3, QLSP has non-state bar funding that requires that it provide civil legal services to non-indigent clients. In October 2020, the working group was in favor of lowering the presumption threshold to a range of 51 to 60%. And then it also took into consideration those recent grant administration updates that I talked about and the community feedback. The working group initially landed at a, I think, range, or a percentage of 55%, but with the community feedback, I think they were more in favor of the highest point in that range of 60%, which lends to the working group recommendation below, which is to codify office practice by lowering the primary purpose threshold to 60% and establishing a minimum threshold of 50%. That latter piece is more so to say more affirmatively that informal practice, informal guideline of having QLSPs or applicants report below 50% as ineligible for ILTF funding. I'll pause here. This is the second, this is the substantive piece in which there was more clarity from the working group. They were in a range and now have confirmed 60% as their recommendation in consideration, again, of those updates and the recent community feedback. I'll touch on issue number 3 if there's no other comments. So the third issue was the commission discretion regarding the any other means test. So this is in tandem with State Bar Rule 3.671A and then Rule 3.671C, which gives the commission discretion to find organizations that do not meet the 75% test as eligible if they demonstrate by other means that their primary purpose is to provide legal services without charge to indigent persons. Other means in the past has included providing historical expenditure information or having a demonstrated track record. The working group revisited this rule and then maintained that discretion is important because it allows flexibility and also a mechanism to address any unanticipated eligibility issues related to primary purpose. And then also keeping in consistent with its recommendation for the issue prior, issue number 2, the working group believes that this discretion would only apply to applicants who have at least established that minimum threshold of 50%. So if you're below 50%, you wouldn't be subject to the any other means test because then it would be consistent with this recommendation here. To summarize, the working group recommendation is to maintain commission discretion regarding the any other means test and then include language noting reasons why and when this test would be used. The next few slides are just the track.
Will, did you have a question or comment?
No, I will wait till after the report. Thank you.
The next few slides here are just the proposed rule updates, which I can also pull up in a Word document, but I did want to just pause because those are the 3 main topics. Just to point out 1 and 3, it was more the same that was discussed. Number 2 is just settling on that 60% as the new primary purpose threshold. So let me stop sharing and see if there's any questions because I can't see anything from my current view.
Will has his hand up, Kristen.
Yeah, I just have one question on this.
Sure.
Related to the calculation of 60% of expenditures may include a reasonable share of administrative and overhead expenses. In my nonprofit work, that can be up to 30% of like a grant. But what is the bar's definition of reasonable administrative and overhead expenses?
Kristen, want me to take this one?
Yes.
So there is a separate codification topic about, budget revisions and within that what we're going to deal with like administrative expenses and non-personnel. But generally what has happened now in practice is that the IELTS EF application has suggested percentages. 25, at least 25, at least 75% have to go to personnel. And when there's deviation to that, we elevate it to the budget eligibility and budget review committee, who can then make a determination. And they have approved budgets when it's deviated from those suggested percentages, because it's not codified anywhere. It's just office practice that's evolved over the years. And that's 75-25. It is in line, I would say, generally, from I've seen kind of the research that's been done by staff, kind of in line with I guess with other funders. There's a lot of variation though, and that's part of why this is the codification process is that this topic is going to come before the commission to see if there should be a hard and fast rule. And Jim, and I believe Jim's on that working group, so I don't know if you have something to say, or if you have another question.
Yeah, I was just going to say that when you're talking about law school clinics, you have, depending upon the university you're dealing with, they have certain rules and regulations in terms of what overhead is. They don't call it just administrative. Overhead is a broader concept in the university context, but it does require some flexibility. In the very few clinic programs that we funded, and there's only about 4, I think, they have some exceptions to the administrative cost issues to conform with the university's overhead requirement.
I believe that is a separate codification topic on law schools, and then these recommendations are also specific to QLSPs as support centers, or I think they're regrouping those related issues.
That's right.
So if my math is right here, if I had a budget of $1 million and 25% went to admin or to overhead, I'll just use the term overhead.
We don't use that term overhead, so it doesn't quite, I don't know your definition. We are admin, non-admin personnel, non-personnel is kind of the terminology that's used in the IELTS EF application. And I think there is a lot of overlap with overhead, but I don't know if the way you're using it is synonymous.
I was just quoting it from the rule, administrative and overhead expenses. So I guess I don't know exactly what it means. But if it is 25%, that's considered a qualified expenditure, and that gets deducted out. Doesn't it then make the it
doesn't get deducted out? We allow it.
We allow it as a qualified expenditure.
Yeah.
Okay, so then the actual under the 60%, then the actual required qualified expenditures that are non-administrative or overhead.
No, it includes. Or maybe I'm not understanding your question. So we don't back out of those admin overhead expenditures. So that is included in, but maybe I'm not understanding your question. Maybe Crystal.
Well, yeah, I'm trying to understand. Like I'm trying to use real numbers, because if it's just the percentages, I'm like, okay, what are we?
So qualified expenditures are, so those are based on the audited information that QLSPs and applicants submit. And then based on that application, there are deductions as in terms of non-qualifying work or any other work that we deduct out. The piece that Dwan is talking about, that's actually in the budget portion, which we confirm before I think the allocations are made. But we would assess the submitted audited financial statements if there seems to be higher percentages or any other flags like that. But there are some checks in place to deduct non-qualifying expenditures.
Right, that makes sense. I guess just that last line leaves me wondering, since what a reasonable share of administrative and overhead expenses is, and that gets added in, and so it's not just straightforward 60%. There's some unknown variable of these costs that also are going to be considered qualified expenditures, at least as I read it, but I could be wrong.
And that's, no, that I think if I'm understanding you, yes, the reasonable like admin and that's like I said, it's a separate codification topic where we're gonna like define what that is, and then think about whether there should be a hard and fast rule within the admin, if there should be some cutoff that you then can't or you can't budget towards.
I think I might have been hearing Will's question to be like, it's a reduction from 75 to 60% is the proposal. And of that 60%, because it includes admin costs, that it's actually less than 60%. And does that mean it should be higher than 60% because it's including the admin costs? So I hear the worry being that it's not a true 60% of expenditures for direct legal services because it includes the admin costs. Did I get that close, Will?
Oh, okay.
Yeah, nailed it.
Okay.
You said it so much better.
So are you suggesting that
I
we
just
should,
was listening carefully.
are you suggesting we should raise the 60%? I guess, what are you suggesting?
I guess it's hard for me to say that we should raise it without the other number. They are the teeter-totter here. So if they are really limited and, you know, it's only 10% difference, but if it's 30% and all of a sudden they can actually have less than total 50% just by saying, oh, it's going to admin and overhead. That's where my concern is.
And I guess I wouldn't say that they would say that it's just going, because I think programs would say they need their administrative and their overhead in order to do a proper job of delivering quality legal services. So that is legal services.
Yes, I agree. I just, as I read it, as we're trying to figure out primary purpose and that 60%, what it actually means. And as I read this rule, it doesn't actually mean exactly 60% because it's dependent on the other definition.
Well, I think
that
maybe sorry.
Oh.
Go ahead.
I was just going to say conceptually, it might help. I think that what the rule does, and it, I would argue makes sense, it sort of looks at the thing separately. An organization that does 100% of the services that it does is providing legal services to the indigent is going to have 100% under this number. But that organization is, you know, they're going to have some overhead, and what the percentage of that is, and what's proper could, you know, if they're super inefficient, we deal with that in this other rule. But there's still 100% primary purpose, because even if they're super inefficient, all the work that they're doing is still legal services to the indigent. If that makes sense. So one's this is measuring the focus of the organization, how much we let them, you know, count as administrative costs is sort of their efficiency.
Yeah, I think so. If you think about it, this is how I think Will gets there, because he raised the 50%. If it's at 75% and they happen to spend 25% on indirect admin kind of costs, you would always know that at a minimum 50% went to direct legal services, right? That would be your minimum. And by reducing it to 60%, it's gonna, you no longer know that there's always going to be 50% to direct legal services. That's what I hear the question be. I'm just trying to explain what I understand Will to be saying.
Yeah, I think that's spot on. And it may be that reasonable share is actually going to be low enough that this is a non-issue. But that's what made me a little uncomfortable, is that it could end up with organizations having really small provision of services compared to their overall budget. I guess what would be helpful if we could have an example at some point, even if we vote on this and decide on it, maybe at the commission meeting, just an example of how this actually breaks down would help me understand what these numbers mean in application. Wouldn't be in a plan. Sorry, Brady.
I was going to say, sort of an answer to that, the other thing to consider is, so, you know, an organization does activities, some are qualifying, some are not. They have to, whatever their overhead is, they have to be apportioning to both of them.
Yeah.
So I don't know if that observation helps, but it sort of helps me.
Yeah, I assume there must be something conceptually I'm missing, and maybe I just need to go through it. I don't want to take up the time at the meeting, but I don't want to end up in a place where we're paying for a lot of inefficiency.
Yeah, and I think that's why when the separate topic, we can do a deeper dive in it. But I think maybe Crystal, I don't know what a representative sample would help you, but maybe we can give you the range of what in the prior year's budgets. Crystal, could you do a range of like what the admin breakdown is? I don't know if that would help the range.
During this call, I don't know if I would be able to have that. What I was gonna show, I don't know if this is helpful or not, was an actual IELTS EF application for the 2023 year to show like how the QEs are calculated. But I think as Brittany was mentioning, like they are apportioned in terms of what would be qualifying and not qualifying in those related administrative expenses. I have an example here that I can share screen if that's okay, Dawn?
Yeah, of course.
Yeah. Okay, so this is an example of 2023 IELTS EF application. These amounts derive from total corporate expenditures, which is from the submitted audit. And then scrolling down, as I mentioned, there are some questions that ask about potentially non-qualifying work. And so in the explanation, there are identified administrative or overhead that would be associated with non-qualified work that applicants would have to deduct. All of these end up with an item of percent of qualified expenditures, which is that 89%, and we're looking to, the working group recommendation is to decrease that to 60%. One of the main reasons is that when you look at the number of applicants who are below 75%, there's actually a number of repeat organizations, and each year they have to submit a narrative, this less than 75% explanation, and they're approved they're approved every year. So I think that was to streamline that. That doesn't really impact the way that qualified expenditures are being calculated. I don't know if this is helpful, but just like a visual, this is how it is, and this is how qualified expenditures are calculated.
Yeah, and if you scroll down right now, it's 75%. So what the trigger is that, we run a report and programs are less than 75%, we elevate that to the eligibility budget review committee to do a closer review. So if you change this rule in practice, what would happen is we change this question to 60%, and that would be then the trigger. If you're below 60% rather than being below 75%, it would get commission review. Catherine?
Thank you. So is there any analysis of the impact of the recent changes? So we are now going to make many more things qualified that wouldn't have to be deducted, which will make qualified expenditures higher. But so simultaneously, we're reducing the threshold for what is primary purpose. And like, I'm just trying to understand the intersection of those two things happening at the same time.
Oh, hi, Rich. I think maybe we can, he was on the working group too. So if you wanted to chime in, I think that might be a good time.
Well, I was going to make the same point Catherine just made, and that is qualifying expenditures that would be counted this year would not have been counted in prior years because work might have been done for those who were not identified, not defined as indigent under our guidelines. So Catherine's point is that we're going to have more expenditures that qualify, and we don't really know what that's going to do to this number. But if you go back to the chart that is Crystal put up in front of you, the number of QLSPs involved at a lower level is very small from year to year as it is. What we were trying to do is work with staff to reduce the number of elevated discussions that happen every year in order to more streamline the process But I think gathering data, to Will's point and some of the others that have been made over the next few years, if you see that the number of non-qualifying goes up substantially, I'd revisit this.
Or
Yeah,
the
to
other
answer
choice would
Catherine-
be to leave it, right? And get the data and better understand it now, right? Because I think it's gonna go up, and on the natural, because it goes up, the number of people that are below the threshold will be smaller than it is now. And so I guess I'm just trying to understand, like, because there's such a sea change, not only with the poverty threshold being up to 200%, which for the large LSC programs means, everybody's going to be eligible, right? Along with the changes in what is a civil legal service because of the statutory definition change, that it's going to be more unusual to deduct expenses than it is currently, because the threshold increased by the income threshold alone increased by 75%. So I think it's possible at 75% you'll have nobody.
So yeah, we and for us to do the analysis, to answer your question, Catherine, because this is the first year those statutory programs can. So then we were talking about waiting until it would be for the 2024 application when they apply next year, 2024 funding when they apply next year.
So
And that would only
have
then
a
only be
sample.
1 year. That would only be in 1 year data.
We'll have 1 year of data, Catherine.
We have no data now.
What is the urgency of changing it, knowing that this is happening and we don't know the implication? That's all. Because the workload honestly isn't like that high. There's 3 in last year or something, right? So the choice kind of is make a change now and go back and have to go through the process of changing the rule, or wait until there's a couple of years of data and see if in fact the rule needs to be changed. That's kind of the choice, right?
Yeah, I think the working group toyed with a number of different levels here. LAC assisted us with a memorandum that supported the number that we finalized on. I don't think it's a question of urgency at this point, although especially since we don't know what the end result is going to be.
Just to follow along this, or do we have any sense or thought about, because I know this has come up in other contexts where we're talking about, our kind of general expectation of QLSPs who are applying for funding on a regular basis, that there may be, this group that's in the 60 to 75% range will sort of maybe elevate, or 50 to 75% range will elevate, and there may be another tier of groups that sort of fill that spot. Or is that kind of unlikely given the landscape that we have right now?
So I think with the minimum threshold that's being presented, that tier would be 50 to 59%. And so it's really hard to surmise because you don't know the impact. We do have a sense that everything is expensive now, and the chances are that qualified expenditures will be higher. I think 60 felt comfortable to the working group just looking at the past 5 years of the QE percentage ranges and sort of using that as a guideline. More so looking at the past versus the future, which is still, it's still uncertain, but 60% felt comfortable for the working group.
Yeah, it's really, Amin said it nicely, I thought, which is, so I think the people that are currently like between 50 and 60 are going to rise up because who's eligible is going to be higher. So they're going to be above 60, maybe even higher and not subject to review. And does that make, is there going to be a group that now currently is not eligible, but that could become eligible? And is that a good thing or not? I don't know, because I don't know anything about who the applicants are, but there's, I don't know. it's just like an unusual time to me to make a change when we don't yet know what the impact of all of this amazing work that was done to change the eligibility standards. And I honestly, I'm probably most comfortable to like just say, let's revisit it once we have a couple years of data and leave it as it is now, because I think the workload's going to be reduced on the natural, and then see where it lands and what's coming in. But you know, as they say, I'm one vote, and so I respect all of you. So if you have other opinions, I'm interested in them.
Will, do you want to go ahead?
I echo those concerns, and along with the others I've raised, though I'm not totally opposed to lowering it some percentage, some smaller percentage in recognition of all those changes, but maybe not as comfortable going all the way down to 60% when we might want to see how these other changes shake out, just for where I'm at, if that helps anybody.
Thanks, Will. Rich?
One of the things that crossed my mind when reading the LAC memo and also when considering this with the working group was that this might in fact increase the number of eligible QLSPs. And I think generally there was a sentiment that might be a good thing, that we might have more legal service providers than the current number, to be more inclusive rather than to be leaving the rule where it was. So while there isn't an urgency in the sense that I think Catherine meant it, there's always an urgency in finding more lawyers willing to give their time to provide legal services to the poor. So I want to put an asterisk on the word urgency. And I guess I can throw in something that Crystal heard me say before, and I was expecting Jim would echo this, but there are ways of determining primary purpose that vary from using expenditures to define primary purpose. I mean, it strikes me that the most obvious way to determine primary purpose is to look at how hours are spent by the QLSP rather than where money is going. We've always used the money aspect of it for primary purpose, but thinking outside the box, when we were discussing this with Judge Seligman and Corey, everyone felt more comfortable using dollars expended to determine primary purpose. But the reality is, as a practicing lawyer, question is, where are you spending your time providing legal services? In order to determine your primary purpose, you would add that up and you'd get more than 50 to define primary, which is Judge Seligman's point, I think, if I remember correctly. We've been using 75, but the reality is if they don't hit the 75 number, but they're above 50, they're generally approved, right, Duan?
Yeah, I was just going to make that point. So some of this is also, I mean, I don't know if it's urgent the way Catherine you mentioned, but it is an equity concern for us because right now in the rules it's a 75% presumption. So there is an impression with like non-IELTS new applicants that you have to be at least 75%. There are people, you know, our programs know, especially the ones that are below 75%, that the commission, at least in recent years, has never denied somebody funding below 75%. And in fact, there are some that are very close to that 50%, and the commission has always approved it. So we just wanted to reflect kind of, you know, what has been happening to be fair to non-IELTS funded organizations, programs that have never applied before. So it was a part of an equity consideration, but.
And those programs would now be eligible to count a larger number of expenditures that might in fact get them closer to the current 75%, right? So the equity, like that's just both of those are excellent points. Of course, we want to, people that are qualified in providing effective services, we want to include, but it's like everyone's going to be able, including new programs, be able to count a far greater number of expenditures, and we just don't we have no data yet on what that looks like, right? And so it just, like, I don't know, it's just unknown, I think.
Does anyone else have any thoughts on this issue and the timing of how we approach? Jim?
Yeah, one estimate on what you can do is in terms of the increase in the population that could be served. I mean, it is quantifiable to know what the population is 120% versus 200%. I think it adds a couple of million,
Like
but I
5
don't
million.
have the numbers right off.
I think
the
it
top
adds
of my head.
5 million eligible Californians roughly.
Yeah, that sounds about right. Yeah.
So I guess a follow-up question to the committee. So there were three sort of issues identified. One was an administrative update to delete reference for budget of the coming year. Two, which is what we're discussing now, was regarding the 75% presumption threshold. As a subpart to the issue number 2, there was a recommendation from the working group to establish the 50% minimum. I guess I wanted to know what the committee's which would also impact the recommendation for issue number 3, which is regarding the any other means test. Just wanted to gauge whether or not those should be grouped together, or if the committee felt comfortable on voting on some of those items. One would just be more administrative, so it would codify office practice.
I mean, for me at least, one doesn't pose a problem at all. I mean, I think that makes sense. Nobody submits I mean, you can't base it on data that you don't have, right? So you don't have budgets, programs don't do budgets so that makes sense. I guess I'm not, by codifying it 50%, I like, so great, but then the rule's really just 50%, and then why are we having a 60%? Like, I don't quite, that's why I just don't quite understand the intersection of new rule change. There's going to be a threshold at 60%, but if you meet 50%, you're eligible. They seem a bit inconsistent with me, and then I end up not quite understanding why we're codifying 50% when we're setting a threshold at the proposal is to set it at 60%.
Because there has been discussion in the past. We did, the commission has once voted to find a program eligible at 49. And I think there was somewhat controversial that we felt like it needed to be at least 50%. So that's why this is coming before you. Should a program even be considered eligible if it falls below 50%? And you know, Rich, please, because you're representative from the working group, but I think the working group believes it should be at least 50%. And then the 60% is the presumption. 50% is the minimum. Crystal, maybe you want to go over it one more time.
No, I got it. So it's like 50% is the minimum.
Yeah.
And if in the end, you're determined to have 50% qualified expenditures, then you're eligible.
No, you're not automatically that the way it, yeah. But you have to have at least 50, but it's not automatic. If you have 50, then you're found. Between that 50 and 60%, how it's drafted now is you would get elevated for committee review, and above 60%, you know, you don't get elevated for commission review.
Wait, let me just see if I can help, because there seems to be some ambiguity that I didn't think existed. If the expenditures are 60% or greater, there's no discussion at the eligibility and review committee.
Yeah,
that automatically qualifies.
So it's the
below
same.
60.
Yeah, and that's what happens now if it's at 75%.
Correct. And
right?
if it's but those that are not at 75 but are above 50 are then the subject of discussion one by one.
Yep.
By lowering it from 75 to 60, the number of discussions, the number of deeper dives into budgetary, into the expenditures will be reduced. And
maybe, or maybe it'll happen otherwise.
Say that again?
Because more, sorry. I'm sorry, I apologize.
No, that's okay. I just to finish my thought, anything below 50 is generally not going to be considered at all. That will be disqualifying. That hasn't changed. What is changing here, what is proposed to be changed is simply at what point does.
No, that does change, Chris. I'm sorry, Rich. The 50%, because even below 50%, we elevate it for you to consider. This would be automatically, if you're at 45%. I mean, obviously the commission still needs to do the approval, right, in August, but it doesn't get that level of review, because if you approve the recommendation and it gets approved as a rule, 50%. Crystal, unless I'm misunderstanding, can you clarify?
Yeah, so the 50% is an informal guideline, so that it's the commission's practice, but it's not in the rules. So that's why we have an instance of an applicant with 13% qualified expenditures that got elevated for the committee and commission.
No, but if it was if you approved the way the recommendation is drafted now, then practically, can you play out what would happen if an application comes through that's 45%?
They would not be able to move forward and be found ineligible for ILTA funding.
But would it be picked up in the any other means test?
No, with the rule as drafted, if they don't meet at least the 50% minimum, then they would not be eligible and wouldn't meet primary purpose.
Brady, did you have a comment?
I was just going to clarify sort of, and I think this might go towards Catherine's question, so the 50 to 60% where that's going to be elevated, I've always seen that as, I mean, the commission's not going to say, oh, you're actually at 55%, but we're not going to find you anyway. I think it's more, isn't it more, oh, this is kind of close, so we should look at these and make sure it's truly over 50%. Isn't that the inquiry that happens? So it's basically, hey, some of these might be debatable, so let's just make sure that this is truly over 50% and therefore meets primary purpose.
Yes, that's I think accurate characterization. Or Erica, did you have something?
Yeah, I mean, I think there was some discussion on that point in the most recent round of applications about like, what is the purpose of looking at these, below 75%? And there was a question, because there are those organizations that always come in below 75. I don't think it's really a question, are they above 50? It was, do we want to just say that, because yeah, there really isn't a question about whether they're above 50, because they were at like 65%, but they do need to be reviewed every year. And so whether the committee is treating this as like, well, if you've done it before, but you're below 75, we're just gonna say that's fine, or do we really need to scrutinize this with the same level of detail every year? So I don't think it's just about qualifying expenditures and whether they've actually like made the right deductions and are exceeding 50%, because a lot of them are not even close to 50. I would say this year, I think none of them fell below 60. So it's the nature of the discussion was, is this really meeting the intent of the funding if they are kind of providing all these various services? And I think Catherine and Jim were there, so if they want to say anything about that discussion, but I think it was more like a philosophical discussion, not just looking at the expenditures and making sure they're right. So
I had one more question. It was in response to that what just went back and forth between Crystal and a commissioner. I'm sorry, I'm forgetting who it was, but that I'm looking at attachment A here, and my understanding actually had been that that it wasn't a hard and fast 50% rule, at least codified, that's sort of been practiced, and that we could still imagine a situation where, due to a one-time, a one-time dip, if they could show, hey, we've always been above 50%. And, this year we weren't because of X reason, but we always have been in our plans, budget for next year is to be back over 50%, that would still be something possible under the C. And I just wanted to clarify that. Is that accurate or not the intent?
Yeah, can you clarify for us, actually, Crystal, because
That is exactly my question, really. Like, that's why I didn't say it very artfully, but like, what is the rule What is the rule about primary purpose?
So the rule right now is that if they don't meet, if organizations don't meet 75%, then they get elevated, 75% qualified expenditures, they get elevated to the community commission. I think the recommendation, working group wanted to sort of establish a minimum, which maybe probably wouldn't be conducive to that scenario if they fell under 50%. But currently there's no bottom, like there's no, if you're under 75, you can still be elevated to the committee or commission to determine whether or not the work you provide meets the statutory intent of primary purpose. So 50% was, and I think an idea and the recommendation from the group, seeing as it would maybe be consistent with the informal practice of really only looking at those who are at least 50%.
But Crystal,
But I don't think that's not
under the new rule though, is that if you're below 50% is what Brady asked, can you still evoke by any other means?
No. So in the memo, it talks about like in the scenario that you're at the minimum threshold, but still below the 60%, that's when any other means test. In the case that you're under 50%, you would just not be eligible, or that you wouldn't meet primary purpose.
But I feel like the rule says, essentially it creates a firm 50% threshold that if you meet, you are eligible. And maybe we're looking at it now to say like between 50 and 60, are those expenditures, do they really make sense to us? But there isn't really discretion to look at what I think Rich was saying, which is like, or Jim, somebody was saying like, are there other ways to look at eligibility that should be considered rather than just a straight, it's a percentage only? And I think that's what we're going to lose with like, if it's 50%, and if the commission says those expenditures equal 50%, they don't have the discretion to say like, really, is that really what they're doing? Like, right, those kinds of things. So I mean, it just becomes a much more hard and fast rule the way that it's written.
And I'm looking, maybe we should put something out because I'm looking at the posted item.
Yeah, and I just realized that too, Brady, apologies. The 50% minimum is not, it's not on there, even though it's with the recommendation, but let me share my screen.
Oh, so that might be the confusion then.
That's probably where, I mean, it was a very aggressive timeline to get these memos posted, so I apologize. But let me share my screen. This is the deletion that I think no one has issues with for deleting reference to budget. That's for issue number 1.
Yeah.
And then this has the 60 to 70 change here. And then this is C that Brady was referencing, which is it does not establish that 50% minimum threshold, which I don't think the committee is in favor of. So maybe no changes are needed, but this was what was posted.
So what would have changed there, Crystal? Can you just point out?
What would have changed is if there's an agreement for that 50%, I think there would have to be some additional revisions here that a qualified support center or qualified project that does not meet the test, but at least 50% of qualified expenditures may nevertheless apply. That would be the adjustment, but maybe I think hearing from the committee that probably is too restrictive to.
Yeah, this is so this everything I've said is based on this, which is what I understood, and I guess I'd missed that there was until
but in the memo though,
there was a talk about a 50%.
But the memo does talk about the 50% though.
It does.
Right. That's why it's So I'm really sorry. Like we have 6 minutes left, and I have another call at 3. So I'm like, what is the most helpful thing we could do? Like, I'm happy to meet again. Like, if I appreciate the urgency of the 12th is like, can a working group meet again? Can something?
I haven't noticed it. And it does seem like, if I'm hearing Catherine and Will may not be in favor of moving things along. I don't know, Jim, Amin, your feelings, but if you guys are in agreement to not move it along, then what I would say is the working group continues to work on this, then we advance civil legal services and Indigency next week, and then those two get advanced to the board in November, and this will just be worked on more, or we definitively decide to wait, as Catherine suggested, maybe a few years to get more data.
So, and I'm sorry, I understand the one thing that's moving, but I thought the C part was, I don't know, is it C is the second part? That seems connected to what we've just been talking about.
Those are both connected. So, I mean, if the whole thing, the whole issue will lie, that's fine. I think maybe there's a request for additional information to make a more informed decision in terms of an appropriate threshold or changes if that's necessary. So, I guess I defer, Dwan. I defer to the committee in terms of what they want to do.
I mean, maybe Amin should make the call as chair.
Yeah, I mean, Jim's had his hand up for a while. We only have a few minutes. I have a thought on this, but I want to hear from Jim, and to the extent Brady has. Okay, Brady's. But go ahead, Jim.
Okay, well, I haven't served on budget and eligibility very long, but when we were considering these exceptions, I was told that past practice, that almost always in the past, the committee has approved those that were above 50% or at 50%. I never actually read any that were at 50%. Most of the ones were at 60%. Most of the ones had qualified in the prior years. That's why, to answer Rich's question, maybe what you ought to use is a moving average over the past 5 years or something, so that these momentary dips below 75% doesn't matter, doesn't require full committee review. And it's my speculation that if moving it down to 60% plus increasing the eligibility by 5 billion in the state, that we're going to have far fewer, because most of them are barely just not meeting it. It's not like they're at 45% or 30% or something like that, or even 50%. So I have no problems with the proposed rule change to 60%.
Okay. Thank you, Jim. My thought on this is that in the interest of time and getting this moved forward with, you know, everybody sort of satisfied that we've examined this and especially in light of the additional data that we may get, I agree with Jim in the sense that I don't know that this is necessarily going to have an impact that we may need to be concerned about, but I do think that there would be some value in seeing what the impacts are and avoiding a situation where we may want to make one change and then have to make another to the same rule. I'm going to suggest that we move forward with the other two proposals next week and then table this for a later time.
Do you mean move forward, like take a vote now to move forward in August? I mean, sorry, at the commission meeting, like, so vote now as a committee for the first two and table.
Sorry, I mean, when I say the first two, I mean the other two.
Oh, gotcha, the other two topics.
Gotcha,
okay.
And because I think these three, as much as some of them are not controversial, I think there's interrelation that we may just want to be careful not to make multiple changes to the rule.
Well, this might go against that, but I think there is the one change about the budget in number A. I mean, that's something where the rule doesn't actually meet our current practice, and that might be a simple change to move forward without messing with the thresholds. At least make that.
I agree with that. The budget is,
that's a good point.
I agree.
That's a good point. And does that, from a procedural standpoint, are we running into any concerns if we make that change and then revisit the same?
You might. The only thing is the board might not take it up because it's not a big issue, but I can try. So we can.
Well, aren't they all going to be together? I thought the point was we were trying to get these all in a package to go in November.
Yeah, but the package is like the big issues, and this now doesn't feel like more of a technical. But again, we just vote on it. At least we have it on record, and then Brady and I and Eric are taking those agenda items to the board, so we can try to figure it out. I just don't know. That's what I'm saying. I can't give you assurance that I can package it, that particular one, for November. I've only been pre-approved for the three, but I think we could deal with that offline.
Okay, so I'll make the motion that we adopt the first change proposed in the memo with respect to the budget So as reflected in what Crystal has up on the screen, with the 60 changed back to 75. Do we have a second?
Catherine seconds.
I'll do roll call. Al-Saraf,
Yes.
Fightmaster, Bennett,
Yes.
Blakemore,
Yes.
Bushelli.
Yes.
I'm sorry. Will, did you?
Yes.
Okay, thank you. Connolly,
Yes.
Meeker,
Abstained.
motion passes.
Okay. Thank you, everyone. I think
Did we vote on the other items already, or do we?
We didn't.
I
Being
think
said
we
to table it.
Oh,
right?
no, sorry. I thought, was there the earlier? I'm so confused. Was it, we voted on the item we first took up, right?
Eric,
yes.
yes.
Yeah, excellent. Okay, sorry. I just want to make sure that.
Oh, change mine to yes, if it's the first item. I thought we were talking about the
I'm
last
sorry.
item.
So I think Catherine's question was the first topic on the agenda. And then I think what you're saying is, Jim, we're just voting. Crystal had 3 proposals. This is just the first one that was a technical change.
Okay,
And you want to change it from abstain to yes for the record?
yes,
Okay.
yes.
Okay. So I think we passed unanimously.
So yes, that's still motion passes, but we've made a note of your vote, Jim.
Great.
Okay. So I mean, can I say a couple words? Because this is
Sure.
the last meeting of this rules committee, of this grouping of rules committee for the 2021-22 term. And I just want to thank everyone, especially Amin, for your leadership the last few years. We are really at a point, we put a lot of hard work, 2 or 3 years. Like I said, we're really excited to take these items to the board in November. There's still a lot on our work plan. So with the new chair, we are going to have to revisit and see what are the priorities for the next year or two. You know, when we originally set out in this endeavor, I think people had thought it would take a year. And now we're going on year 3, and it's probably going to take another 2 years if we're going to be realistic in the process. But thank you so much.
And how about a big thank you to staff for all your amazing
Yes.
work and developing
Here, here.
proposals, and really amazing. Takes a lot of time.
100%. It's
I'll
been a
second that.
significant undertaking, and the lion's share of the work and analysis has been done by staff, and it's been an incredible. It's made, I think, my job certainly, and I think our jobs collectively as commissioners on this committee much easier, knowing that the staff has invested so much time and effort into the analysis, into the community feedback. Thank you to Selena and LAC
Agreed.
for being a partner in this. And thank you to Dwan for spearheading and leading the efforts and the administration of this process, which is not easy. And it's, again, as you mentioned, not going to be a quick process. And when we started this was pre-COVID and all the other things that we've had to balance. So thank you, Dwan. Thank you to staff. Thank you to everybody on the committee. And I'm excited to see what comes in the future. I think we've got a lot of interesting things coming along. So thank you to everybody.
Thank
See you all
you.
next
Bye,
week.
everyone.
Yeah.
You.
Take care.
Yes.
Bye,
More to
everybody.
come.
Everyone.
Good afternoon, everyone.